circumstances, I'm mentioning a matter which was, my lord, directed by your lordship to appear as urgent motion today. Last Monday I had mentioned it, but it's not there. My lord, my lord.
Why not, friends? Why it's not? File आ गया? Okay, it will be listed tomorrow. Actual file has not yet come from the department.
And one more, my lord, since I'm mentioning one matter, because last week I didn't know, perhaps Tuesday and Thursday, I had given a notice regarding a restoration application. May it appear on any day, my lord. I've given the notice, my lord, for the day, my lord.
My lord, this is restoration application I mentioned.
My lord grants me leave to mention a matter, my lord. My lord, I am for the petitioner in this matter, my lord. My lord, the matter was supposed to appear today. The copy of the order is there, my lord. If my lord allows my mentioning, my lord.
It's not in the list.
No, my lord.
What is the matter?
It is a matter of illegal mining, my lord.
Might be the file not yet come. That's why it is not listed.
My lord, it is urgent,
With
my
order.
lord. Yes, my lord. Order. And the second page of the order. The state authorities.
Affidavits completed.
Yes, my lord.
Reply affidavit pleadings completed.
Yes, my lord. Inspection has also been done, my lord. And recent inspection was also done. Spot inspection, my lord.
कल रख दो. कल रख दो.
My lord.
कल रखिए.
Grateful, my lord.
Hearing में.
Grateful, my lord.
May I have my lord's leave to mention an urgent motion, my lord?
Why
I'm
it is
mentioning-
urgency? Today is not the mentioning date.
My lord, only for inclusion, I'm mentioning upon notice to all. The matter was due to the matter was due to appear on 4th November, my lord.
Yeah,
And my lord, the respondents were supposed to come with instructions. My client has wrongly credited the amounts in the wrong bank account, my lord. Only reversal is required. The banks were supposed to come with the instructions, my lord. Any day convenient to my lord, it may appear as a motion. I shall give one more notice if my lord so desires.
Wednesday, urgent motion.
Lordship.
My lord, under a compelling circumstances, my lord, mentioning, my lord.
All the
My
matters
lord,
are
my lord, the
done.
passport of the petitioner has been, my lord, illegally seized by the authority.
What?
But passport of the petitioner has been illegally been seized by the
What's
authority.
urgency on that?
My lord, petitioner cannot move, my lord, outside the country for his even medical treatment, my lord.
When he is supposed to go on medical treatment?
My lord, any day, my lord.
Why? There's no doctors in India.
My lord, kindly, my lord, see the matter, my lord, illegal. That has been illegally,
When
my
the
lord.
passport was seized?
My lord,
When the passport was
without giving any reason.
there is any criminal case?
My lord,
There is any criminal case?
no, 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 no.
So how the passport has been seized?
That is the question,
Who
my
has
lord.
seized the passport?
My lord, the airport authority.
Airport authority.
Yes, my lord. Kindly, my lord.
Where is the seizure memo?
My lord, that is not presently with me, my lord.
The seizure memo. There will
Yes,
be some
I
case
have
of-
annexed that. I have annexed the same in the writ petition, my lord.
Ah.
I have annexed the same in the writ petition, my lord. दादा এটা নেবেন দাদা
अरे भाई वो ले ना अपना काम बाद में कीजिए.
Grateful, my lord.
Wednesday, urgent motion.
Grateful, my lord.
Take TCP matter, my let it be.
No, he has called the list.
My lord. Under the my lord.
Lordship, on the last occasion, Lordship has heard the matter. This matter relates to defreezing of the bank account, my lord. My lord has directed to appear today in the list. My lord, it's not in the list, my lord.
Why it is not listed? हमको बताते क्यों नहीं है जो लिस्ट में हम बोले हैं फाइल नहीं है तो why you not mention asking me informing me अब हमको क्यों नहीं बताते हो मैं तो 7 बजे तक रहता हूँ क्यों नहीं बताते हो जब मेंशनिंग ये मैंने डेट दिया जब फाइल नहीं है तो you could have been informed to me at 5:30
My lord, under the
Keeps it today at 2 p.m., my lord.
क्या देखो
My lord, at 2.
What is the urgency?
My lord, defreezing of the bank account, my lord.
Why it has been freezed?
My lord, without any notification to us and without any verification upon the complaint, which has been done by one of the partner, my lord. My lord has heard it, my lord.
Okay, come on Wednesday.
My lord, under
Urgent,
My lord, then kindly keeps it tomorrow, if not today.
urgent motion will be taken on Wednesday. Come on Wednesday.
Much.
My lord, under the precarious circumstances, may you permit to mention, my lord, in this matter, my lord, Lordship has already passed the order in sitting in the execution matter on 27th of October. Now, my lord, we have already pointed it out to the regular executing court has been pleased to grant us leave by Honorable Justice Aniruddha Rai
For what?
to take appropriate steps because the order has not yet been uploaded. The department, the server shows that the order has been passed on 27th of October 2025. My lord, kindly remember it is an execution application. We're hearing that, my lord, please to protect us. Till that the order has not yet been uploaded. Even in virtual also, my lord, the order is
Come at 3. It is origin said come at 3:30.
as your lordship is. I'll come back.
Origin said come at 3.
I will come back.
May I have my lord's kind leave?
Electricity matter, let it be listed.
It will be listed. You will leave.
No, my lord. It was in the list of my lord.
Okay, it will be listed when the
After 1 week after the.
okay file is not in the department. That is, it has not been listed. Let it. If the file will come, all the file will be listed. All the matter will be listed. No problem.
May I have my lord's
Lordship,
kind leave
similar-
to mention, my lord, item.
Only with the electricity there is no urgency.
May I have my lord's kind leave to mention, my lord, item number 11 of my lord's today's list, my lord. I mean, led by Mr. Bhattacharya, my lord. He is little unwell, my lord. I have mentioned it while I'm mentioning about notice. All I'm seeking is for an adjournment, my lord.
Come when the matter is called.
Very
Take
well.
a mention.
I will. Grateful.
Mentioning for inclusion in the
Huh?
For non-prosecution.
For non-prosecution.
My lord, matter including inclusion, my lord.
Lordship, may I be permitted to mention a matter for inclusion?
For what application?
Inclusion application, my lord. Inclusion application.
Huh?
Inclusion application.
Inclusion will come on the.
Lordship, this is a matter pertaining to electricity. 20 lakhs was deposited to be directed before the vacation. We have deposited it. Thereafter, also the electricity has not been restored. Your Lordship, the matter was supposed. No, Your Lordship. It was supposed to be listed a week after vacation. It has not.
Mention tomorrow. Come tomorrow. Come mention tomorrow. Tomorrow is the mentioning date. Yes, call the list. Call the list.
Last week I mentioned, my lord, directed to have come on Monday.
Lord, in item number 1,
198.
Lord, in item number 1, my lord, I'm from the petitioner, my lord, which has come up at file number 225, my lord. This pertain to issuance of no objection certificates from the Ministry of Steel, my lord. We have received instruction that the no objection has been received, my lord, so it may be withdrawn, my lord. We have received instructions from the client to that effect.
The matter is listed as to be mentioned on the prayer made by the counsel for the petitioner. When the matter is called today, counsel for the petitioner has handed over the communication dated 4th November 2025, issued by the petitioner,
Serial number 1
the learned counsel for the to the learned advocate for the petitioner, informing that the Ministry of Steel has already accorded necessary no objection certificate to the petitioner, and as such, the petitioner is intending to withdraw the instant application. In view of the communication dated 4th November 2025, counsel for the petitioner prays for withdrawal of the writ application. Consider the submission made by the counsel for the petitioner for use the communication WPA number 13672 of 2025. Is dismissed as written. Communication dated 4 November 2025 be kept with the
My lord, I am for the petitioner, my lord.
yes.
My lord, if you lordship kindly fix this matter, my lord, 10 days hence, my lord.
Why mention?
My lord, it is a mention, my
When
lord,
the matter is mentioned, that is the problem. You persons are mentioning
No,
when
my
the
lord,
matter
in
is
the-
listed on the list.
in the.
Then fix
in-
Tuesday, fix Wednesday, fix Thursday.
My lord, perfectly, my lord, I bow down to your lordship.
Go out
my-
of the list.
My lord, kindly
The
appreciate, my lord.
record and order.
My lord, kindly
The matter
appreciate,
is
my lord,
listed as
matter
to
may
be
be
mentioned on
settled
the
out
prayer
of.
made by the counsel for the petitioner. When the matter is listed, the learned counsel for the petitioner prays for time. According in case is adjourned, let the matter appear in the combined monthly list of January 2025, 2026.
Madam, appealing for this one number 6 in this matter, madam.
On indulgence, my lord. My lord, matter may be settled out of court. That's why, my lord, I am praying for some accommodation. Kindly fix this, my lord, 10 days hence, my lord. My lord, only my lord grant my lord liberty to mention, my lord.
Interim order is refused.
Lordship, item number 3.
Yes, call the matter.
Lord, item 3, my lord has
She refused.
refused the interim order. The writ petition is disposed of, or my lord has
Affidavit direction.
refused the interim order?
Refused interim order, no prima facie case, so affidavit direction is.
As well as. Good.
Lord, my lord, I beg to appear on behalf of the petitioner. My lord, this pertains to my lord West Bengal Highways Act. My lord,
Lord,
I am
Lord, prior to open the brief of my learned friend, Lord, I have something to say. Lord, on 15th of January 2022, I made an application for allegation for unauthorized construction. And Lord, this is the writ petition filed by my learned friend. This is the third round of writ petition, wherein, my lord, I have not been implicated as party in that proceeding, although the proceedings initiated by my allegation. And therefore, my lord, kindly allow me to intervene in this application without passing any order, because they purposefully or intentionally not included me as party. My lord, the earlier writ petition, my lord, being writ petition number 7737 of 2024, the writ petition was filed by me. And my lord, in pursuant to that writ petition, my lord, the Honorable High Court Coordinate Bench directed to initiate the proceedings under Highways Act under section 10(1), 10(2), and 10(3). And my lord, this is the third round of writ petition wherein I have not been implicated as party, because, my lord, earlier 2 times, my lord, all the proceedings initiated de novo, and my lord, the appeal, even the provision of appeal under the Highways Act, that had been exhausted. The appellate authority directed to demolish the unauthorized construction. But, my lord, in this way, one after another writ petition is filed. And, my lord, again the matter, the delay-dealing tactics is adopted.
Yes.
My lord, if my learned friend wants to get himself added as a party, I think, my lord, he should take out an application. So far as, my lord, he says that it was on the basis of his allegation that, my lord, the proceeding was initiated. Now, my lord, things are coming back to my mind. Possibly, my lord, he is correct, my lord, in saying so. Though, my lord, in the writ petition, my lord, not drafted by me, I did not find any reference to that. But, my lord, possibly my learned friend is correct, my lord, in saying so, that, my lord, on his allegation, the proceeding was initiated. But if, my lord, kindly just have a look at the impugned order once, my lord, there is no reference also, my lord, to his, my lord, submission, subject to, my lord, of course, correction by my learned friend. In the appellate authorities order also, my lord, there is no reference, my lord, to his submission, that something weighed with the authorities, my lord, with regard to his submissions. That is not there. And, my lord, may I just show the impugned order once?
Yes.
Where the urgency is, my lord, is this. My lord, I have been told that, my lord, my lord, construction would be, my lord, demolished by today. That's what, my lord, I was told, which is why, my lord, the matter was mentioned.
Yes.
Kindly, my lord, just have a look at page 20. Copy page না একটা কপি ওনাকে দিন না পার্টি অ্যাড হন না হন একটা কপি দিন উনি এসেছেন যখন একটা কপি দিন ওনাকে kindly come to page 20. My lord, this is the order passed by, my lord, the competent authority, my lord, first time. Then, my lord, this was carried in appeal. Kindly take, my lord, the third paragraph rather, my lord, at page 20. The learned advocate of the respondent submitted that on a previous occasion, the respondents were prosecuted under section 10(3). My lord,
Where you are reading?
my lord, page 20, annexure.
Yes, the learned, yes.
Third paragraph, my lord. Learned advocate of the respondents, my lord, indicating us, submitted that on a previous occasion, the respondents were prosecuted under section 10(3) of the West Bengal Highways Act before this learned court for their alleged encroachment. Perusal of the case records of eviction. Case records of eviction, case number 493 of 2022. My lord, this is the earlier round of litigation which my learned friend was referring to. Is necessary for effective disposal of the instant case, being eviction case number 182 of 2025. My lord, then, my lord, it is important. Upon perusal of the above two case records, it would be evident that there are different and contradictory demarcation reports filed by the same authority. Such demarcation reports are mutually exclusive. The learned advocate of the respondents did not submit any document in favor of the encroachment by his clients. I cannot submit a document to show that I have encroached. The representative of the PWD submitted that the substance of the case is that there is encroachment of PWD land being plot number 530. This is also important. Why I say this? The earlier round of litigation was with regard to a different plot altogether, 698. Mouza Alangiri, jail number such and such, portion of land encroached upon has been clearly demarcated by BLLRO in demarcation report prepared on 8 December 2023 by Revenue Inspector. I have taken a specific point in my writ petition that if this was the foundation of the order impugned, then I ought to have been provided a copy of this, and particularly when there were two contradictory demarcation reports. This court, so this was possibly a third report subject to correction by the authorities. This court perused both the BLLRO demarcation reports pertaining to this eviction case number such and such and eviction case number 493. On perusal of the reports, this court is satisfied. Court is satisfied that there is encroachment of PWD land being plot number 530 and it has been clearly demarcated in BLLRO report. Hence, the order is passed.
Yes.
So, this is absolutely based on a sole document, a demarcation report, though, there is a contradictory demarcation report. The demarcation report ought to have been, served on me. Now, kindly turn to the appellate authority's order. Appeal, I am not, troubling your lordship with. I have also annexed a copy of the appeal. I'll just check, whether my learned friend was a party there in the appeal. He was not.
No, he is not a party.
He was not. Now, the appellate authority's order is at page 33. Kindly see, the order. Page 33.
Yes.
On behalf of the state appellant number 5 is present in person, advocate for the appellants is present. On behalf of the state respondents, representative, etc. present, heard the case, perused the order passed by such and such, wherein subdivisional magistrate and 4 others who are illegal encroachers of PWD land number 530 to remove encroachment within 15 days, failing which will recover, assistant engineer will recover possession. Learned advocate on behalf of the appellants objects over the demarcation report and stated, though there are several other encroachers over the said government land, submits a list of such and such 147 unauthorized encroachers, alleges that only selectively his clients are served with eviction notice. The list of encroachers is made a part of the proceeding. Then, the reasoning comes. On perusal of the report and hearing, it is inferred that in the said government plot, there are several encroachers along with the applicants. Hence, the order is passed. So, that's a one-liner, which is the reason. Now, kindly have a look at. So, this order should go, subject to, of course, what my lord, thinks proper because of, lack of reasoning. Just a one-liner. Now, kindly have a look at the act. So, I'm thankful to my learned friend. May my lord hand up. I'm thankful to my learned friend. Lord, section 10, removal of encroachment. If any person is found to have made an encroachment on any road, here the allegation is PWD road, street, path, way or land which is declared to be a highway under subsection 1 of section 3. Now, section 3 subsection 1 deals with gazette notification for declaration of a stretch of land as a highway, which was significantly not present here, not shown. Is declared to be a highway under subsection 1 of section 3 or makes an encroachment on a highway as declared in contravention of the provisions of section 8 or does not remove an encroachment on the expiry of cancellation of any permit, that was not the case here. The highway authority or any officer authorized by him in this behalf shall serve a notice on him requiring him to remove the encroachment and restore the highway to its original condition with the period specified in the notice. If the encroachment is not removed within the time specified in the notice, the highway authority or the officer authorized under subsection 1 make an application to an executive magistrate. My learned friend was suggesting he has made an application. The application is possibly required to be made by the highway authority or the officer authorized to the magistrate having jurisdiction over the area, not being the district magistrate, for removal of encroachment and delivery of possession. Such magistrate may, my lord, this is important then, such magistrate may, on receiving the application and after notice to the person responsible for the encroachment, and on taking such evidence, if any, as he thinks fit, make an order authorizing the authority or officer to recover possession and remove the encroachment in question, and may, if necessary, direct the police to assist. Then, my lord, if the person does not do
Okay,
so,
these are the proceedings.
yes. So, my lord, evidence is, my lord, to be required to be adduced. My lord, I take it, my lord, against me, that, my lord, that
You are appearing for?
Well, I have not been implemented
You are
as
appearing for?
the alleged complainant.
alleged complainant.
Who is the complainant?
Milon Niranjan Bera,
Who is
who
he?
was the writ petitioner in WPA number 7737 of 2024.
W7, WP number?
7737 of 2024.
Yes.
And my lord, my lord, in that writ petition, my lord, on 15th,
Okay, whatever it is, now I am saying the order passed by the authority.
I'll make him a party.
You will be added as a party in the petition, and I will serve the director serve the copy
Yes,
of the writ application. And if you want to file affidavit in opposition, you file the affidavit in opposition. If you don't want, then I will fix a date for hearing.
And, my lord, kindly allow me, my lord, to use a supplementary affidavit also. My lord, I personally feel that, my lord, when there is a previous round of litigation, I must disclose that. My lord, the disclosure is not here. Possibly, my lord, might have been, my lord, drafted in a hurry. My lord, kindly allow me, my lord, liberty to file a supplementary affidavit. I'll serve upon my learned friend also. उन्होंने कोर्टे मामला
Affidavit of service filed by the petitioner be kept with the record. Learned. What's the good name? I forget.
Shankar Prasad Dalapati.
Mr. Shankar Prasad. And advocate submit that the order passed in the impugned writ petition is on the basis of the case initiated by namely
Mr. Niranjan Bera.
Niranjan Bera.
by one Niranjan Behera. But the writ petitioner has not made the said person as a party to the instant writ application. Though the said person is the necessary party of the present writ application for proper adjudication of the case. The counsel for the petitioner has filed the present writ application challenging the order passed by the sub-divisional magistrate Agra dated 18th June 2025, passed in eviction case number 182 of 2025, and the order passed by the appellate authority dated 28/8/2025, wherein the subdivision magistrate 2025 the subdivision magistrate by an order dated 18th June 2025 has come to the conclusion that the petitioner is in possession of the government land and directed the petitioner to vacate the possession. Being agreed by the said order, the petitioner has challenged consent before the appellate, that is the district magistrate Purba Medinipur, and the appellate authority has rejected the appeal and confirmed the order passed by the subdivision magistrate. The petitioner had drawn the attention of this court to the order dated 18 June 2025, wherein it is recorded that there are two demarcation orders, and two demarcation orders are contradictory. Subsequently, on the basis of the demarcation order passed by the demarcation report, the subdivisional magistrate has passed the impugned order. The contention raised by the petitioner that from the face of the record, it reveals that the subdivisional officer has passed the order on the basis of the demarcation report, but the demarcation report has not been served upon the petitioner. upon the petitioner. As regard the order passed by the appellate authority, it is submitted that only with one line the appellate authority has rejected the appeal of the petitioner on the ground that peruse the report and hearing, it is inferred that the said government plot, there are several in culture along with the applicants, and accordingly appeal is rejected. Considering the above, this court find that the sub-division magistrate has passed an impugn order without serving the demarcation report to the petitioner, and the appellate authority has passed the impugn order without assigning any reason. Under said, this court finds satisfied that the petitioner has made out a finds case and balance of convenience and inconvenience, and the application is to be convenience. And as such, the impugn order passed by the sub-division officer dated 18 June 2025 and the appellate authority dated 28/8/2025
এটা বললে বল না অর্ডার পাস করে দিলে আর শোনে না তার কথা
straight till the disposal of the writ application. Full stop. So and so जो ऊपर नाम दिया ना, the petition is directed to add so and so as respondent number.
That will be respondent number.
As respondent number
7 possibly.
7.
8, my lord, 8.
Respondent number 8. By
আমাকে
course of the day.
My lord, the advocate on record, I am told, has not yet come to
By
my lord, by tomorrow.
By 12th of November 2025. And to serve the copy of the writ application along with the copy of
Copy service করতে হবে।
documents to the added respondent.
নাম বাবার নাম
The added
অ্যাড্রেস নিয়ে যা
respondent
করার
at liberty to file affidavit in opposition within 2 weeks on receipt of copy of the writ application. A reply, if any, there to be filed within a week thereafter. Please the matter on 3rd of December.
Kindly grant me a leave, my lord, to use a short supplementary.
The counsel for the petitioner submit that there are some document which the petitioner could not, which the petitioner could not disclose in the present writ application. Accordingly, prays for file supplementary affidavit. Let the supplementary affidavit be filed
within a week, my lord, it should
within
be
a
done.
week after serving the copy to the London consulate for the private added respondent as well as the respondents.
My lord,
Officer,
then the opposition to be filed after
yes, the petitioner, the private respondent as well as the respondents are at liberty to deal with the supplementary affidavit in the affidavit in ऊपर बोला 2 weeks बोला ना 3 weeks का.
Great.
Your lordship has pleased to stay the operation of this order.
Yes, till the disposal of the writ.
The only one thing, my lord, when I was from the state when I could not come before your lordship at the appropriate time, rushing from court number. The only thing, my lord, in paragraph 6, where the main grievance of the petitioner was, your lordship has passed the order, I am not saying anything on that. Only one thing, but the main grievance of the petitioner was that prior to the passing of the order, he was not being heard. If your lordship kindly sees paragraph 6.
No, not heard. He is heard, but the report which you relied upon, that has not been
He
served.
has not challenged that order also, that report, but that demarcation report.
Maybe.
The auditor has challenged that report prior to.
And have you gone through the order of the appellate authority? Where is the reason? One line cannot infer. That's all. Where is the reason?
Great.
Lordship, item number 5, I am for the state, Lordship. My video is off, Lordship.
I'm appealing for the commission. My lord, I am
appearing for the respondent number 5. Am I audible? Am I audible to your lordship?
Yes.
Lord, I am appearing for the respondent number 5.
Item number 5.
5, Mlad, this is for Mlad EWS certificate, Mlad. Mlad, my prayer is against Mlad, the state authorities. I have no relief sought for Mlad against the commission, Mlad.
You have.
Mlad, EWS certificate issues, Mlad, in every financial year, Mlad, based on the financial condition of that respective year, Mlad.
Correct.
Now, Mlad, certificate was issued prior that to Mlad in 2021, Mlad. Rather in 2020, Mlad. I have annexed at page 16.
Yes.
But this is valid for 1 year only. Now, Mlad, that's why, Mlad, I applied for next time at page 17, Mlad.
When you applied 2004 and 2024.
16, page 17.
Page 17, when you applied for?
Mlad, applied on 4th July 2025. as it appears from the receipt. Now, page 19 is the my application to participate for the post of assistant teacher to the commission, school service commission. Here, in the category I have applied under EWS in the middle.
When you applied for, when the application was filed?
Application was made on
7 July, 10th July.
Yes,
10th July.
10th July 2025. And my category I have mentioned EWS.
Correct.
Now, in the meantime, OBC certificate was issued. I do not want to avail the benefit of OBC. That's why I want to forego this benefit. That's why I have applied under EWS. This certificate is yet to be issued. That's my grievance.
Now, when you applied for the OBC certificate? When
22.
OBC was granted on when?
22.
22.
15, 10, 22. This is online certificate.
Yes.
15, 10, 22. The only my prayer is let my certificate be issued. But only difficulty is I must tell you, the scheme that is prevailing in the state that states that if you belong to OBC, whether you apply for OBC or whether you have the certificate, you cannot take advantage of EWS. A similar matter I have done before another coordinate bench. Well, my submission was recorded, instruction was taken from the state, and thereafter the court has directed the state to change the portal. Where I have to apply for EWS because the portal was restricted only to those who in whose favor OBC certificate has not been granted or whose surnames are not appearing in the OBC list. Only they can apply. That portal possibly subsequently changed and certificate was issued in that matter. A similar order may be passed in my matter, in this matter also. অনেক কঠিন কাজ আগে দিয়ে হয় না গো
So what has happened to this writ petition?
It was disposed of ultimately last order because certificate was issued in my favor in that writ petition.
No, Lordship. That is only the portal was updated. That is the observation of the order. That it has been brought to the notice to this court that the state has already upgraded the portal for issuance of EWS certificate. That is the observation of the court, Lordship. Honorable court, Lords.
Yes, what is the submission?
Lordship, the Manla Chowdhury SDO has joined just a few days before. He informed me that he requires some days for instruction, Lords.
Only urgency is the
When the last date?
or verification possibly going on. They cannot apply.
The prayer which he has sought principally is that the SSC should allow him as EWS candidate without the certificate.
That's why
the last date was on 21st of July 2025. It was long over. And thereafter certain dates were given for editing the caste category. My lord, that date was lastly given on 22nd of September and it expired on 26th of September. He till date do not have, my lord, the EWS certificate in his hand. And my lord, there are decisions by Honorable Supreme Court which I'll be relying, which says that till the time the certificate is issued to a person, my lord, he cannot be considered as a EWS category. So, my lord, in this selection process, my lord,
Naturally. That's why I'm asking, because in the state pays for time. So now last date is over. How soon you will come with that instruction?
Lordship, day after tomorrow.
You are appearing for?
well, I am appealing for the School Service Commission. It's point number 5. I was led by Mr. Bandopadhyay, my lord.
Let the state come.
না ঠিক আছে ওটাই আগে তোমার সার্টিফিকেট না
Senate Council appearing for the respondent number 5. Prays for time to take instruction according case set down. Let the matter appear on 12th November as urgent under the heading adjourned.
Can it be on 13th?
13. Okay. 13 going.
Great.
Affidavit service kept with the record. Item number?
Grateful, Lords. Lordship, my appearance may kindly be
For the
recorded.
state led by Mr. Fishana Madhuban.
Who is for the petitioner?
I am for the petition.
Yes. What is your grievance?
There are tenders related to supply of fish feeds.
Supply
Sir,
of fish
floated
feed.
in, yes, 2018, there are 4 tenders. Lord, the 4 work orders were issued to the petitioners, Lord, after becoming successful. Now, it was issued in between January and February 2019. Lord, the conditions was, as soon as the relevant demands made under the work order, I need to supply within the specified time. My lord, in respect of 3 work orders, my lord, whatever demands, my lord, have been made, my lord, we supplied. My lord, no dispute raised, my lord, all fish feeds were consumed. It was used, consumed. Invoices were raised, my lord, time to time. My lord, the total invoice was 3 crores 75 lakhs and odd. But out of which, my lord, they paid 2 crores 8 lakhs and odd. My lord, the balance was, my lord, more than 1 crore 66 lakhs. My lord, we repeatedly then, my lord, wrote the issued demand notices, but they remained silent. My lord, then, my lord, we an RTI was, my lord, made, and there was a response. My lord, kindly take, my lord, page 233 straight away, my lord.
36.
233.
Yes.
It starts from 232, my lord. I'm sorry, my lord. It starts from 232. But these are the related, my lord. 233, kindly take.
233.
233.
233. Yes.
The time period between supply of fish feed by Honorable Feeds and the date of sending the samples as made in annexed to, however, date of testing and analysis.
Where from you are reading?
Page 233. It starts from page 232.
Correct.
For the response. But I'm just reliving last reply to serial number 3M. Has you got it?
Yes.
A committee was formed consisting of 3 officers of Fisheries Department, namely Additional Secretary, Director of Fisheries and Financial Advisement. The recommendations of the committee was the payment to the concerned agency may be made as per work order. But what they observed, that it was all used. Now, despite these recommendations, no payment was made. We filed these writ petitions.
Where is the recommendation?
This is that recommendation we are not supplied with. We have asked for, my lord, but it was not supplied with. My lord, kindly take page 230. That was our, my lord, requisition. It starts from 220.
Committee was formed consisting of 3 officers. Advisor,
Yes,
the recommendation of the committee was the payment.
my lord, N. Please provide the copies of the record, report, documents, memos, opinions in respect and or in connection with the supply of balance.
Page
230, 230. Now, this was our RTI query.
Please provide the details including a name and designation of the email. Yes.
Yes, those were now only this response came and they said that the committee had recommended for payment. Despite that, no payment released. Just from SPIO Administrative Officer, Director of Fisheries. This was in response to my RTI query. Page 233.
So what is the answer to these queries?
They did kindly come back to the response on our page. It starts from page 232.
Acha, this is 229 is the answer of 233.
Yes, 232 is the response. It starts.
Correct. 233 serial number 3M.
Yes, this was the response.
Yes.
But despite that, there are demand notices. We asked for the payment.
So what is the reply to the affidavit?
Yes. Now, when we filed this writ petition, they came up with an affidavit. Kindly take page. In fact, these contents, they have also supplied the test reports done, subsequent to my, after consumptions. Earlier they took samples and they tested after the consumptions. Now, in the test reports which I have annexed, my samples, there was no failure of my supply.
Okay, what is the reply in the affidavit?
46 of the affidavit in opposition. If you also has got it. Now they say that some of the samples failed, so no payment should be made.
46.
46. This is the last page. Is there another review committee was constituted?
হার্ড করবো অপরচুনিটি ফ্ল্যাট করার
Yes. Now kindly take my work order. There are similar work orders, all similar. So I am just showing one work order.
Whether after the supply of fish feed, is any notice was issued to you?
Nothing.
In accordance with the
Nothing.
Yes.
Only after the filing of writ petition, this came.
Okay.
Kindly take page 105. It starts one of such work orders. All are same.
Yes.
These are the parameters mentioned. What should be the parameters? I can show from the test report that so far as my suppliers are concerned, those met the parameter. Can you take page 106?
Yes.
Top, the implementing authority. Has you also got it? Implementing authority or his or her representative reserves the right to reject any fish feed found to be inferior quality. So if they detected before consumption, so they could have informed us and rejected the supply. The fish feed rejected by the implementing authority or his shall be replaced by the supplier in his own cost on the date fixed by the implementing authority. That they did not do. What they did, my lord, they consumed it, they used it. Then, my lord, the assessment of the quality control of the fish feed will be as follows. Authorized representative of the Director of Fisheries will collect samples at random from the fish feed supply at the delivery points of the concerned district and get this sealed, signed by representative of the representative of the supplier send the sample to the government approved testing. Payment will be made against the supply fish feed only if the test results of the sample conform to the specifications. Now, in the present case, my lord, as soon as I raised the bills, my lord, my payment started coming. My lord, in fact, more than 2 crores has been paid, but the balance were not paid. They did not reject any of the fish feed. My lord, they consumed it. My lord, the committee recommended for payment. Then, my lord, they constituted a review committee and said that no payment will be released to him.
Review committee means?
That is the 46 is the review committee report. Okay. It is not the recommending committee. That you will also kindly take, my lord, again come back to 46 of the affidavit in opposition. I read from the top, my lord. Yes. Pursuant to the order number such and such dated, the Principal Secretary Fisheries Department, members of the departmental review deliberated at length on the recommendations of the technical committee as submitted by the Director of Fisheries. That I had, my lord, shown, my lord. Then it was observed by the members of DRC that the technical committee concluded the supply feed being poor quality would definitely hamper overall fish product and the lower presentation of protein, lipid, fiber content would not provide adequate. In spite of this, members of the technical committee recommended deduction of 25% of the total amount of the bill. Well, I don't know, but that recommendation didn't contain any such deductions. Members of the DRC observed that the recommendation suffered from two gross influence. A uniform deduction of 25% of total amount of bill for all types of supplied feed, irrespective of the quantum of deviations from the stipulated specification, was too simplistic. The fact that the fish feed was consumed prior to obtaining the test result, resulting in inability of the consumer to return the faulty consignment, the reason cited by the technicality for imposition deduction cannot absolve the suppliers of their burden, absolute liability to supply fish feed conforming exactly to the specification noted in the tender document. And this breach of contract as observed.
Okay, you have shown, but how you said this is a review committee? It is in compliance of this 233.
Yes.
233, it was sent to the committee. The committee has taken the decision.
Now, 233 is there was no question of constituting a review committee. 233, kindly again come back. This is the technical committee.
Correct.
Yes.
A committee
now, they said,
committee was formed of 3 officers of the fisheries, namely so and so. For the fisheries department, recommendation of the committee was payment to the so and so. So kindly see who has signed. Fisheries Department, Commissioner of the Fisheries, Director of the Fisheries, and the Finance. They are the person.
This is SPIO, my lord. It was in response to the, my lord, Right to Information Act. This is the special public information officer. My lord, he is. But the committee had this recommendation is there for payment because since they have consumed.
Where is that? Kindly read serial 3M.
Yes, a committee was formed consisting of 3 officers of the Fisheries Department, namely Additional Secretary, Director of Fisheries and Financial Advisor to the Fisheries Department. The recommendation of the committee was the payment to the concerned agency may be made as per work order.
Correct. So
yes.
That's why the committee has considered and it is found that your fish was not up to the mark and that's why it has not been given. So,
question is, my lord, when once it was consumed and once
that is the point of now you are telling that the review committee.
Yes,
it cannot be review.
No. That is the point I am urging.
Yes, Mr. Anything further?
No, only thing if
yes, Mr. Banerjee.
Yes, my lord, the point of concern, but he is not disputing that his feed was of inferior quality.
No. I have said
he is not. When he says that after consumption, why have you taken steps? That means that he is not disputing that his feeds are of inferior quality. Now, question is that whether it could have been done or not, whether the work order contemplated that or not. Now, kindly comes to the work order, my lord, if you lordship take the affidavit in opposition, But though most of the papers are there in the writ petition also, but it is in a concise form, my lord, in the affidavit in opposition. Kindly take page 12 of the opposition.
Yes.
Yes, my lord, your lordship will find in the middle of page 12 that the quality of the fish feed which is to be supplied has been specifically mentioned. That what should be the diameter, protein, fat, fiber, moisture, and polyunsaturated fatty acid, etc. All the parameters have been given.
Yes.
Now, my lord, kindly turns over to the next page. Page 13 top. The implementing authority or his or her representatives reserve the right to reject any fish feed found to be of inferior quality. The fish feed rejected by the implementing authority or his representatives shall be replaced by the supplier in his own cost on the date fixed by the implementing authority. The assessment of quality control of fish feed will be as follows. Authorized representative of the Director of Fisheries will collect the sample at random from the fish feed supplied at the delivery point. This is very important. Of the concerned districts, get these sealed and signed by the representative of the Director of Fisheries and the representative of the supplier and send the same to the government approved testing centers. Payment will be made against supply of fish feed only if the test results of the sample conform of the specification. There is no condition attached of usage or non-usage. Time for completion of the work is so and so. The corrected bills invoices as per accepted rates so and so. Then kindly second part of the last bullet, the payment will be made by the concerned DDO of the district on recommendation of the implementing authority. At first, payment will be made in accordance with the sanction amount. Remaining payment, if any, will be processed after getting requisition from the concerned implementing authorities. Now, my lord, kindly, my lord, there are other same work orders are there.
Mr. Banerjee, kindly come to the page 13, the first.
Yes.
Implementing authority or his representative reserve the right to reject the fish feeds found to be inferior quality.
Right.
Fully stop. The fish feed rejected by the implementing authority or the representative shall be replaced by the supplier. Have you informed with regard so
No,
that he can replace?
Yes, my lord, we are not on the replacement as yet. My lord, the question is that, my lord, he is saying that why you have used it. Now, my lord, these are, my lord, if we do not use it, it will, my lord, go to waste. Then, my lord, what is after the random sampling, whatever is left is used, and when the test result comes, only then we know that it is inferior quality, and thereafter, my lord, the payment is made. But that also is clearly stated, my lord, that the payments will be made if it conform with the specification. My lord, the second bullet point in the same page.
Correct. But the question is that okay, you have taken the random collection and sent to the lab for testing. If testing it has come, so you could have been, because why this word has been given, why this sentence has been given, the fish feed rejected by the implementing authority or representative shall be replaced. So you have to inform this quantity of
May I put it in this way, my lord? Those two paragraphs your lordship will find are not connected with each other. One part, the second part which I am relying on is the payment. When he will get payment, he has not come before your lordship to say that I want to replace the inferior quality. He has come to say that so and so amount is due from the government and that amount should be paid to me. The second paragraph comes into effect by saying that the payment, when the payment will be made.
Okay.
He has not come with the offer that you allow me to replace it. Let him replace it. We have no problem with that.
Okay.
And if the replaced quantity, if they accept that it was inferior and if they replace it, we will pay according to the replaced quantity. We have no difficulty with regard to that. But my lord, I am sure my learned senior friend will not agree to that. Will not agree to that. Let him replace it. I have no difficulty. Now, my lord, kindly takes.
But the replacement, how? What is the quantity he will replace?
I'll inform him. But he will not agree to that. My lord, first let him agree to that, then we'll take up that exercise. Then, for example, now kindly takes 2 pages. We have given several test reports, and all these test reports are there in the writ petition also, so they were aware of it. Kindly takes page 30, for example. Takes at page 30, serial number 6.
Yes.
Your lordship kindly takes the 5th and 6th column. First, I am placing the 5th column. Ether extract. 5, serial number 6, 7, 8, and 9 I am placing.
Yes.
Your lordship will find the percentage of ether to be 3.33, 4.34, 5.22, and 3.97.
Page 30.
Page 30.
Page 30. That is the sample code. Moistures. Okay.
Ether extract. Kindly see sample, moisture, crude, protein, and extract.
Correct.
Ether extract.
Yes.
Malad, this ether extract is similar to malad fat. Now, malad, your lordship will find that all these 6 serial numbers are under 6%. Serial number 6, 7, 8, and 9.
6, 7, 8, 9. Yes.
Your lordship will find that all these are under 6%.
Correct.
Now, malad, kindly turns to malad page 12 again. That is the work order.
Yes.
Your lordship will find in the box, first line, the fat should be above 6%. Therefore, all these feeds are below the fat percentage. Now, it kindly comes back to page 30. Take serial number 6 and serial number 9 in the fiber section, fiber. Last column. Your lordship will find serial number 8, fiber is 8.2, and in serial number 9, the fiber is 8.6.
Yes.
Now, Malad kindly comes to page 12. Fiber should be less than 8%. But here the fiber quotient is more than 8%.
Yes.
But similarly, Malad kindly takes another example at page 38. Page 38.
Yes.
Malad, your lordship will find in the box the heading crude protein.
Crude protein. Yes.
Kindly take the third last entry, 24.46 under crude protein.
24.46.
Yes.
Yes.
Now, Malad, in terms of the work order, the protein quotient should be more than 25%.
More than 25%.
Malad, in the same page, under the heading crude fat,
Yes.
kindly take the third last and fourth last entry, that is 4.25 and 5.8.
Yes.
Again, Malad, in the work order, the fat was supposed to be more than 6%. Malad, there are several other such inspection reports. I'm only giving 2 for example. Now, Malad, my learned senior may say that these are samples not supplied by me. Malad, we have given the corresponding entries at page 24 to show that when and where this sampled batch was supplied to us.
Yes.
But I can show it, but Malad, kindly take it from me that whatever I showed your lordship is there in this list. Page 24, 25, and 26. And the heading is that these are all the batches supplied by HON'BLE feeds. Therefore, there cannot be any dispute that these batches were in fact supplied to us by them.
Yes.
Now, Malad, going forward, your lordship will find at page 43.
So what this 24, page 24, what you relied upon?
But page 24 are the serial numbers of the inspection reports that we have produced with the affidavit in opposition.
Yes.
Malad, in fact, I can apprise your lordship, Malad. Malad, the inspection reports are given are of serial number 4, 5, 6. Four, 5, 6, then 11, 12,
yes,
19, 29,
yes,
33, 34,
yes,
55, and then at page 27, 61 to 64.
এগুলো ডেফিসিট ছিল
এগুলো সব ইন্সপেকশন রিপোর্ট গুলো দেওয়া আছে
65 to
64, 61 to 64, 61 to 64. Well, all these inspection reports are there in the affidavit in opposition,
yes,
which they have not particularly denied as far as I have seen the affidavit in reply. Now, my lord, kindly takes page 43.
Yes.
Well, this 43, 43, 44 and 45 is malad the amounts, I'm sorry, malad, the amount for which the quantity of feed, yes, your lordship will find the heading, the third last column, second last column and the last column. The quantity of feed to be supplied, the quantity of feed actually supplied, and the reasons for pending bills.
Where from?
Well, at page 43.
Page
Third
43.
last column, second last column, and the last column.
Not supplied. 43.
43, my lord. 43.
Yes, second last column.
Third last column is quantity of feed to be supplied. Quantity of feed actually supplied, second last column. But kindly see the top.
Date of feed.
Serial number, name of fishery, supply order, name of district, date of supply, quantity of feed to be supplied.
Correct.
Quantity of feed actually supplied, and then last is reason for pending bill.
Yes.
Malad, this document malad contains all the malad data with regard to what was supposed to be supplied, what was supplied, and why the bills are pending. Your lordship will find malad in the last column, say serial number 4, feed sample test report did not match with the specification as mentioned in the scheme or guidelines. Then malad 11, quality analysis of feed sample report does not match with the desired specification of feed mentioned in the supply order. Then serial number 19, not match with report, test report, and so on and so forth. Malad, all the reasoning have been given here. Along with the entire data, what was supposed to be supplied, what has been supplied, and also the amount which is to be paid.
What about this blank serial number 5, 6, 7, 8?
Malad, for these malad, perhaps malad in these tenders, there was HON'BLE feed is not there. HON'BLE feed is not the supplier in these tenders. That is why nothing is appearing against these, because this is a chart pertaining to HON'BLE feed only. In the top, your lordship will find that.
HON'BLE feed, yes. Acha, he has not supplied.
So in these tenders, probably HON'BLE feed was not the distributor of fish feed. So malad, all the reasonings are mentioned in this annexure 3, which we have annexed to the affidavit in opposition. Then malad, in this light of the inspection, tender condition, work order conditions, kindly now read the review committee's order. Now malad, second paragraph onwards I am reading. It was observed, malad, page 46. It was observed by the members of the departmental review committee that the technical committee concluded that the supply of feed being of poor quality would definitely hamper the overall fish production, and that lower percentage of protein, lipid and fiber content in the supplied food would not provide adequate nutrients to the fish, resulting in lesser fish production. In spite of this, members of the technical committee recommended deduction of 25% of the total amount of the bill. Members of the DRC observed that this recommendation suffered from two gross infirmities: an uniform deduction of 25% of total amount of bill of all types of supplied feed irrespective of the quantum of deviation from the supply specification was too simplistic. The fact that fish feed was consumed prior to obtaining test result, resulting in inability of the consumer to return the faulty assigned consignment, the reason cited by the technical committee for imposing deduction 25% of bill value, cannot absolve the suppliers of their bounden and absolute liability to supply fish feed conforming exactly to the specification noted in the tender document, and this breach of contract, but kindly mark that, as observed by the members of the technical committee, cannot be allowed to be let off with only a 25% reduction in payment.
So you compared with that chart?
Yes. The members of DRC further observed that there was nothing in the extant guidelines of Finance Department to making part payment of supplying items not as per specification noted in the tender document. Member of DRC then examined in detail relevant tender document agreement executed between the Director Fisheries and suppliers and supply orders issued to the various agencies for supply of fish feed. It was observed that the Director Fisheries had issued a very unequivocal and categorical instruction to the effect that payment will be made against supply of fish feed only if the quality of feed after being tested at recognized government testing centers be found to conform to the specification. The members of DRC unanimously observed that this condition being absolutely binding on the supplier leaves no scope for release of payment in case of the feed to be found not conforming to the specification. As such, it is unanimously resolved that the committee would recommend for releasing no payment for supply of feed which has been found to be not conforming with the specification noted in the tender document. Irrespective of the quantum of deviation, no payment should be made for feed supplied which on testing at government approved testing centers were found to have been protein lipid content below the specification in the tender document submitted to Principal Secretary.
Yes.
Now, my lord, last thing, my lord, kindly comes to my lord paragraph E. My lord, I'm sorry, my lord, there are two E's by mistake. My lord, kindly take 6E at page 4.
Yes.
But irrespective of decision, my lord, some payments were already in the meantime made. The petitioner number 1 used to submit part bills with the sequence of continuity of supply of fish feed, and as from the record it reveals that the company submitted bills amounting to rupees 3 crores 40 lakhs 96,000 for Moina model scheme, rupees 1 crore 77 lakhs 57,000 for Jal Bharo, and rupees 82 lakhs 27,000 for small water body scheme, 81 lakhs 12,000, out of which an amount of 1 crore 94 lakhs 49,000 was paid by the respondent number 1 for Moina model scheme so and so, for Jal Bharo so and so, and for small water body scheme so and so. This is the chart which I showed in R5. Now, two questions arises from the inspection reports and the DRC. First question is that when the authorities have found certain products supplied by them to be of inferior quality, whether the REIT court is having the expertise to have an alternative view on that, because it's in the administrative capacity that after testing those reports have been generated. And the second issue is that in the DRC report, they are treating it as a breach of contract. Now, in the case of breach of contract, whether the REIT court should intervene and say that the authorities were wrong in taking this step when the REIT petitioner has come before Lordship more in the nature of a money claim, and that claim is nowhere has been admitted by the respondents. Now, we are treating it as a breach of contract. Therefore, they must say their only point against this breach of contract is that the authorities must act fairly even in the realm of contract. This Ramana Dayaram Shetty principle. If that be so, my inspection reports clearly say that my action is not arbitrary apropos the distributor is concerned, because they have been found to supply inferior quality, and supplying to whom? Those who cannot complain.
Correct.
It is very easy to supply fish feeds because the fish won't come and complain. But in the overall production of good quality of fish, there is an impact in the, and which we'll understand over a period of time.
Okay, thank you. Yes.
Yes. First, before he raises that questions, I answered, so far as the law is concerned, kindly take page 102. This is a part of tender conditions.
102. Yes.
102 page. Has you lost it? The clause is C24. Has you lost it? Got it?
C24. Yes.
Stop.
Rejection materials.
All materials brought to the site may be approved by the ADF. Rejected materials must be removed by the contractor from the site within 24 hours of issue of order to that effect. In case of non-compliance of such order, the ADF shall have the authority to cause such remove at the constant expenses of the contractor.
Yes.
There are 2-3 admitted issues here. These supplies were made in 2019. They did not came up with any allegations of failure of taste or rejection of materials. But when we started raising demand, they also said before filing of the petition that the payment has, the recommendations has been made. After filing of this petition, this review committee report came. It says that it was rejected, so no payments to be made. There are three stages. One is what are admitted. Admitted is that there were 3 work orders issued to me. Admitted is we supplied materials and whatever amount they are saying, that is exactly I have mentioned in my writ petition. This much quantity I have supplied, this much bills I have raised, this much payment they have made, this is the balance due. Now that balance due must conform to this, there was no rejections. They admit also that all fees were consumed. And this turnaround came nearly 2 years after the supply was affected. Now, since these questions are raised, I am tempted to rely on a Supreme Court judgment. Probably your lordship is aware.
In reply, you relying the judgment.
Yes.
In reply, you are relying.
Since he has not taken this point of contractual matter, so that he
It is there in the review committee.
The 2023 2 SCC page 703. I'm only, this is a lengthy judgment, only straight away come to page 82.1. But these are all matters relating to the contracts, what the writ will lie, when the writ will lie. But every judgment prior to this was considered. It was also subsequently relied upon in 2024 also. Now kindly take 82 point, I start from 82.1. Or 82.1 to 82.7, specifically 82.6 if your lordship is kindly considered. 82.1 to 82.7, 82.6.
Yes, have you gone through the 82.7?
Yes, I am also considered the existence of an alternative remedy is undoubtedly
Kindly the last line, last three.
Last
In
line.
the writ court, even deciding disputed question of fact, particularly when the dispute surrounds demiscertifying the documents only, the court may relegate the party to the civil court.
But this,
so here you are telling
there is
that
no documents have been
now
disputed.
they have that's why now your question is that the rejection has not been brought on at the spot, you have not been given. So whether the writ court will decide that or the
Yes,
it has to decide
because
during evidence.
this is clearly comes as the arbitrary and irrational actions on the part of the state. Because they should have they should have acted within time. Now, when the payment due is coming, after 2 years, they are they say no, we will not pay.
Okay.
This cannot be allowed. Kindly one thing, paragraph 13 of the writ petitions,
Yes.
I said requisite laboratory tests were carried out by the respondent to satisfy themselves and the material supplied by the petitioners conform to the technical specifications stipulated in the tender and work orders. Copies of the test reports, I have given all test reports. This has been not denied in the reply. Kindly take paragraph.
Paragraph?
This has not been denied in the opposition. Kindly take opposition.
Yes, it is not that it has been tested. It has been tested. Now they have taken the ground. After the test, there was
these statements of paragraph 13 have not been denied. Kindly take paragraph 12 of the affidavit in opposition.
Paragraph 12.
Yeah, of the affidavit in opposition. This was my statement in paragraph 13.
Requisite laboratory tests were carried out. Paragraph 13. Eta.
I've given the test report from all test reports appeared. Yes. Okay. Not specifically denied. But in any event, my lord, I'm kindly visualize the timeline.
Okay.
I have shown 102 that what should be the rejection period and when they should reject it. Now, after 2 years of the consumption, they cannot turn back and say, these are my submissions. Grateful, my lord.
But in the judgment, 82.6 also supports my case. 82.6, 82.6, I'm sorry.
Yes, you rely on that.
Heard the learned counsel for the parties. PAV.
Grateful, my lord.
Yes. I'm grateful, my lord. I'm for the petitioner, my lord.
I appear on behalf of State Respondent.
Well, I'm appearing for respondent number 2.
Who is for the petitioner?
I'm for the petitioner.
This is my affidavit of
This is the reply.
And this is our affidavit in opposition.
Honorable Court.
This is our affidavit in opposition.
You are appearing for?
State Respondent.
And you are
Respondent number 2.
So that respondent number 2's affidavit has not been served upon us.
Have you filed the affidavit?
We have got respondent number 1's.
এটা অনেক আগেই দিয়েছিলাম probably it was not served. Probably it was served earlier.
অন্যটা পেয়েছি ব্যাংকে for the bank.
For the bank. Not served. No, it was served.
Yes. But we have not been, my instruction is that we have not been served. His we have got.
Or you serve the copy?
No, I'm serving the copy.
It's not served.
Very well. Well, I'll just take my lord through.
Ready?
Yes, yes. Well, kindly takes up the affidavit in opposition filed by my learned friend.
What is the case about?
My lord, case, yes. My lord, case is regarding compensation. Land taken under Railways Act, the Railways Act, acquisition done, award given. After giving of the award, the competent authority decides that I was not entitled to get the land and hence directs the bank authority, after disbursement of the award, directs the bank authority that is represented by my other learned friend to freeze the account. That is the case. And after that, he passes an order. After filing of the writ petition, they have disclosed that they have passed an order saying that the award and the order allowing that award, those two were cancelled. My points are twofold. One is that once this Railway Act and Chapter 6, that is Section 20A, from Section 20A, which deals with the acquisition and requisition for special railway purposes, is a special act. Whenever any land is taken away under this act, it will automatically invalidate any action taken under the 1894 Act. Secondly, the competent authority, that is my second argument, the competent authority under this act did not have any power to withhold or direct the bank to withhold the amount, award amount, automatically. The only recourse that he had was to go to the arbitrator and file a Section 17. This was not done. I'll take my lord through the documents once.
My learned friend's submission, my lord, there is no pleading to that effect in the writ petition.
That is not the case made out.
My lord, no, it's the case of, my lord.
The facts are not in dispute.
It's the case, my lord. They are, by suppressing gross material of facts, they are taking the award, my lord, compensation award twice. Firstly, my lord, It has been acquired by the railway authorities and award was published and award was disbursed in favor of the requiring in favor of the writ petitioners. And land was handed over to the requiring body. Thereafter, due to some inadvertent mistake, because the land record has not been updated. So, for construction of a dedicated freight corridor, the land was again acquired and an award was passed. And when it was about to, disbursed to the account of the petitioner, then it was found out that the land was 1958-59. Award was, land was acquired, award has been paid, awardee has got the award, land has been.
Who is in occupation of the land?
Railway authority. Yes.
No, absolutely.
Kindly comes to my Lordship, page 36. Page 36 of my report. Affidavit in opposition. This is the order impugned, I believe.
Page 36.
Last annexure of my affidavit in opposition. Has your Lordship got it, may I place? Whereas it appears that a letter has been received from Senior Division Engineer, Eastern Railway, Asansol, wherefrom it appears such and such error plot number belongs to Eastern Railway. Whereas it also appears that a sanction order regarding payment of compensation against the same LR plots in favor of such and such person has already been issued by this of it, by its sanction number such and such, creditable such having amount of rupees such and such, respectively dated 25th August 2022. Notice is issued to such and such writ petitioner. Case record is put up today for hearing. Notices have duly been served upon the parties concerned. The writ petitioner is present and files hajiras. No representative of the behalf of the DFCCIL is present. After verification of available records and documents attached with the letter issued by the Eastern Railway, it appears that the said LR plots corresponding to RS plot number such and such of Mouja such and such was acquired, were acquired in favor of the railway department by VDA LA case number such and such, and award has also been disbursed to the awardee, namely such and such, wife of such and such. Now, so it is clear that the said land belongs to Eastern Railway, but due to non-updation of record in favor of the Eastern Railway, further acquisition has taken place inadvertently, and as usual, award has been declared in favor of the present recorded owner, such and such. Thus, to protect the interest of the government as well as to save the government money, it is ordered that the award which has been prepared and declared having serial number such and such in favor of the writ petitioner in connection with the LA case number such and such, and award sanction number such and such, credit reference number such and such, having amount number such as respectively dated on such and such date are cancelled. But nowhere in the writ petition he participated in the proceeding. This has been annexed. Totally suppression of material facts. Let a copy of this order be sent to the petitioner.
Kindly
but
see
no
the
one
date of the order and the date when my writ petition was
but
filed.
he was present at the time of hearing. Notices were sent to him.
A writ petition filed in February 23. I believe that order he is showing is of June 20.
Millard, kindly takes my affidavit in opposition, page 3. Page 3 of my affidavit in opposition. Millard, he wants to take the compensation amount twice, cheating the government. Millard, kindly takes Millard, page 3.
Yes.
Paragraph 4, Roman I. Has your Lordship got it, Millard?
Yes.
May I read? That previously the suit LR plots corresponding to such and such had already been acquired in favor of the railway authority as per back as on 1958-59 by VDA case number such and such, by a notification being such and such and a declaration being such and such, necessary word has also been disbursed to the then awardee, namely such and such. It is stated that due to non-updation of the records in favor of the requiring body in the LR stage, the suit plots have been acquired subsequently, inadvertently, mistakenly, and erroneously against LA case number such and such, and an award was declared in name of the present awardee, that is the writ petitioner hearing. Since the said suit plot had already been acquired earlier, and the award had already been disbursed in favor of the then awardee, hence there is no option other than to stop the payment which has already been released to the bank account of the present awardee in order to protect the government money. Therefore, a letter was issued to the branch manager such and such bank, Axis Bank, branch Axis Bank, dated such and such, stop making payment at the award amount. It is all, thereafter, it is also mentioned that another letter was issued to the branch manager, such Axis Bank, memo number such and such, requested to good faith to revert the award amounts of such and such 3 crores, 46 lakhs, 68,705, only in the government account, so that government money can be recovered at the earliest, and simultaneously account of the petitioner be unblocked. Finally, it is stated that a proceedings has already been drawn by the respondent number 1, just I have shown to your lordship below, for cancellation of the sanction order in respect of the erroneous order, which was prepared and declared in favor of the present writ petitioner. In pursuance thereof, a notice has also been issued to the writ petitioner with a memo number such and such for participating in the proceedings. Next, Milord, it is stated that due to non-updation of relevant records, inadvertently and erroneously and mistakenly another acquisition proceeding being such and such was initiated for acquisition of such and such areas of land for the purpose of construction of dedicated freight corridor project under the Ministry of Railways, Government of India. And so that effect, to that effect, a notification under Section 20 of the Railway Act has been published on such and such in the Gazette of India, such and such. And therefore, and subsequently said notice has been published in daily newspapers. We are not concerned about that. Your lordship kindly comes. Kindly, Milord, page 7. Milord, page 6, Milord. Table has been, Milord, given. The award has been prepared in the following manner in respect of the surplus. Next page, the possession of the acquiring surplus have already been made over the railway bodies. So, Milord, Milord, initially, at first, award has been published and made, and amount of money has been disbursed to the Milord petition awardee. Thereafter, in total suppression of that, when in view of the fact, Milord, the land record has not been updated, erroneously, mistakenly, inadvertently, Milord, the second proceeding has been the order as well. Milord, after Milord adopting a procedure, Milord, which he has been a party to that procedure, written notice has been sent to him, this said sanction order has been cancelled. Milord. This is my case.
Yes, 2 points I'll just first point out, then I will take my lord through the documents. One is that regarding suppression of fact, that last order that was shown, that was 4 months after filing of the writ petition.
No.
4 months.
No, kindly come to your affidavit portion.
Yes, that is passed in June 2023.
No, 28th of February 2023, you found the
Filed.
affidavit.
Yes.
Correct.
Correct.
And the order which the respondent state has relied upon, that is of 6th of February 2023, 8th of June 2023.
8th of June,
Okay,
yes.
okay,
June.
Milord, kindly takes his last annexure.
Okay, let it submit.
Yes.
Yes.
One is regarding that suppression of facts. Secondly, that I've claimed it twice is very wrong. I was called upon. I'll show 4 letters.
Correct. Now you came to know that already it was.
It was not. That is the point of law. Let me show the page 30. Kindly takes up his affidavit in opposition, page 30. That is the notifications.
Page 30.
Page 30 of his affidavit in opposition. Well, that is the annexures. Some 5 minutes I will take. It is a gazette notification published in the notification. Gazette notification.
Page 30.
30.
Yes.
Gazette of India, my lord sees.
This is of 2020. This is a new one.
Yes, 20th October 2020. That is the first notification.
Correct.
My lord, under the Railways Act, my lord, I'll just hand over. My lord has a copy of the Railways Act?
No.
Right. Under the Railways Act.
Yes.
The process is similar to the Land Acquisition Act.
Correct.
First, there is a declaration, then there is acquisition. This is the first notice. Kindly seize from the top. 1, 2, 3, 5, 6 lines. This is a special railway project. Kindly marks that word. I'll show my lord why I'm referring on that. This is a special railway project. Now I'll just read from this notification. One thing is.
What number page?
30. Apnari affidavit. Yes. One thing is sure that in 2020, October 2020, the land did not belong to the central government or the railways. In their affidavit, my lord would see there is specific pleading saying that the state in 1950, the state government it was vested in there and it was transferred to the railway. And the documents which have been given for vesting, they show only vesting. They do not show subsequent transfer. And under the
1894 Act, there is a process for cancellation also. It can be cancelled. Let us see this special railways. Kindly turn to the next page.
What you want to show here?
The special, this is for a special railway project.
Yes.
And that on October 2020, the land admittedly did not belong to the central government or the railways, for which there was an acquisition taken place under the special act.
Correct.
I'll also show a judgment which says that special railway projects can be undertaken only through the Railway Act, not under the LA Act.
No, that is correct.
That is not the supplement of choice.
First, you have to satisfy this court whether 1959 you have accepted the amount and the land was acquired or not.
No, I did not accept.
Acquired.
I did not accept.
You had appeared before the authority. Authority has passed an order whether that order you are challenged or not.
My lord, the last order, the June 2023.
Correct.
My lord, that
June 2023,
that
wherein your your award was cancelled and the amount has been requested.
My lord, that one could not have been challenged. The prayer could not have been in my writ petition, but my lord can mold. If my lord sees that that award or that order is absolutely perverse to the law, then my lord can mold my prayers and can finally direct that that order also should be set aside. My lord, kindly comes to the next page. My lord, 31, affidavit in opposition.
Yes.
My lord, sees the date 21st September 2021.
Yes.
Kindly comes to the second and whereas. And whereas no objections were received from the same.
Yes.
And whereas in pursuance of subsection 1 of section 2E of the said act, the competent authority has submitted its report to the central government. This notification is on the basis of the competent authority.
Yes.
My lord, kindly says now therefore upon receipt of the said report of the competent authority and in exercise of the powers conferred under subsection 1 of section 20E of the said act, the central government hereby declares that the land specified in the schedule annexed hereto shall be acquired in the aforesaid purpose. For the first time, this land gets transferred to the central government. So their part of their argument that the land was vested and subsequently transferred in 1958 stands corrected here. Kindly see the next line. That one is also. And further, in pursuance of subsection 2 of section 20E of the said act, the central government hereby declares that on publication of this notification in the official gazette, the land specified in the schedule annexed hereto shall vest absolutely in the central government free from all encumbrances. My lord, the only encumbrance, even if I admit all their points, is that the land was vested upon the state government. My specific submission regarding to that, I'll show also section 20N. This Railways Act and all the proceedings of acquisition under Railway Act is a special act. It deals with special circumstances and it will override any action taken under the General Act. That is my submission. My submission is that they have not been able to show that this second acquisition or the proceedings taken under Railway Act was vitiated. These two notifications have not been taken away. These notifications stand. And if the notifications stand, then the award has to be given to me. Because if this notification stands, the LA Act proceedings that have been taken would automatically go. And I can also show what has been.
Then what would happen then? Which is the benefit you have taken?
I have not taken. Someone else had taken. And if they cancel it, most probably 1958, someone had taken.
Someone else will be taken off of your landed property?
No. At that point of time, this land was purchased by my father sometime in 2021, I believe. 2021. No, I'm sorry. Not 20. It is not there, but because this person's title is, his father's name is Jagdish Gupta, whereas the person who has been paid that in 1958, that person's name is some Dashi.
But kindly see the prayer of the
But that is in page 18, 17, 18 contains, 19 contains the name. Promila Wala Dashi, wife of some Mondol, D. Mondol, top left-hand corner.
Yes.
So we were not the persons who took it. And also, my lord, kindly see page 31. 31 is made after receiving the report from the competent authority himself who had stopped the payment. Now kindly see my name, my father's name, all has been recorded in page 31. Kindly see fourth column, the second 1018, 1023, 1024, 2425, all these are mine, and my name has been recorded. It is not only the central government railways, the competent authority himself has stated that in 2020 and 2021, I was the person who was the owner.
Correct. They are not denying.
Yes.
They
Well,
are
so
not
the
denying
vesting
with
did not
regard to
exist.
the notification,
Yes.
with regard to the award, with regard to the payment.
Yes.
Now they have only one specific. They have taken the defense. Now subsequently they came to know the land was already acquired in 1959. That's why the double payment cannot be made to you, and it is if the government will suffer loss. That's why they have recalled.
I have explanation to that. If, my lord, the Land Acquisition Act says that if the land is taken once, let us say it was occupied for 30 years, then award paid in the meantime, then for some reason acquisition process is cancelled, it is not used, which I say is the case here. It was taken, not used, subsequently cancelled.
Where is the case made out by you?
But
Earlier it was
it is
acquired
their case. It is there from the it has to be their case because in 1958 land was vested.
Sir, you have to proceed your case on the basis of the pleading. What is your pleading? What is your case made out? What is the prayer you made in the writ application?
Well, I'll take Mallet to the prayer. Mallet, from their documents, I'm not saying the fact. The fact is there. In 1958, they have disclosed that there was a vesting. So in 1958, the state government should be the owner. But 2021, it seems that my name has come in. And the state government themselves has stated that this is correct according to our report.
Where is your this 25th August 2022 letter? Where is that? Which you challenge in the prayer A.
That is page 38. That was from the bank. The bank, for the first time, the bank came and told me that this is why you cannot take out the money. I had challenged that action, and kindly see the directions. I have sought the direction. The prayers are perhaps not perfect, but kindly sees prayer F and prayer G. These were there. These were actually praying for the getting of the award.
Correct. So you are asking the bank to release the amount and cancel the letter. Correct, 38.
Yes,
but now subsequently there is development with the document they have disclosed.
Yes.
What action you have to be taken?
That is why I'm praying, my lord. My lord would mold the relief.
The writ petition without the pleading mold of the prayer, how?
Because
now it is to be decided
my lord,
whether the actual it was 59, it was be acquired or not, whether you have received the amount or not, whether the subsequent proceeding initiated by the because of the document was not available with the authority only came to in 2022. These are the three things to be decided, but without the pleading.
First one. My lord, there could not have been any pleading because these documents were not given to me at that point of time. My lord, if I filed
now it has come to you.
My lord, then let us come back with a supplementary.
Why supplementary?
My lord can always
after hearing after half an hour since beginning I am telling to you, you are not understanding. You have half an hour you have taken the time in this court.
That is why I was praying that my lord kindly mold the deal.
If suppose the okay, I agree.
My lord,
I will mold your prayer.
Yes.
But where is the pleading? How the court will decide whether the acquisition was made in the 1989 or our acquisition of 2020 is correct?
My lord, my argument is that if the acquisition under 2020 is supposed to be correct, let us say they have not challenged it, they have not removed these two notifications. Just because these notifications were there, this will directly invalidate any acquisition under 1894 Act. Directly, because this is a special act.
Where is the pleading? That is to be decided. Then they have to give a reply to that. You are not challenged that. So without the challenge, how they can give the reply?
This is a point of law.
Okay, continue. Yes,
well,
yes, continue.
Well, kindly gives a leave to file a supplementary.
Sorry, continue. When you receive the affidavit in opposition and you file the affidavit reply also. Appearing in the writ court.
My lord, there is a pleading, my lord. Kindly see my affidavit in reply, page 4.
Pleading in the reply.
My lord, after getting the opposition only we came to know.
And then reply, you can add a new pleading.
My lord,
it is permissible.
My lord, my lord, I understand. My lord is thinking that we have taken twice. My lord, this is not the case. We have successfully purchased.
That twice or thrice. I am on now at present. I am without the pleading, without the prayer. How the court can go the what you are making is submission for the last half an hour?
My lord, once we got that affidavit in opposition, then only we came to know about the previous.
You came to know what is your duty.
It should have been amended, my lord. The petition should have been amended.
But you have filed the affidavit in reply and wanted to decide the matter on merit.
Then kindly let's us come back. We after a short affidavit, my lord.
Not every bit of details has been well on.
I agree. I agree with that. I agree with that. 1894 Act, the vesting. I agree, but I say that vesting will not be valid in eyes of law. Kindly grant us leave to file a supplementary affidavit.
You are acted on the basis of the instruction of the author. Counsel for the petition, the respondent number 1 and the state respondent number 2 and the state respondents have filed affidavit in opposition after serving the copy to the learned counsel for the petitioner. The counsel for the petitioner has filed affidavit in reply to the affidavit in opposition filed by the state. Let the same be categorized.
Subsequently, my lord, we gathered that he has filed for suit and that injunction has been obtained by him.
That is disclosed.
That's why I am worrying on. That's why I wanted that all the things bring on record.
Well,
from
that
the
is
submission of the petitioner, this court has gathered that.
That is already on record, my lord, in my petition.
Has argued the matter at length, but after hearing, but argued at length, now the petitioner prays for amendment in the writ application. In view of the submission made by the counsel for the petitioner is given the liberty to amend the writ application within a period of 2 weeks. After serving the copy to the learned counsel for the respondents, let the matter appear on 30th. Let the file first. Take the book back. Right now. Yes.
Lord, item number 8, Lord, I am led by Learned Advocate General. Lord, kindly take some order.
What is the matter? Any virus?
No.
I'm just shortcut of this.
Now, if they are asking for this,
I am placing the one issue. Issue is, Lordship, the petitioner is a registered society who usually works for the issuance of OBC certificate who are the eligible. Now, Lordship, here is the dispute of, Lordship, one caste, 2 different names. One is Chasi Koibotu, one is Mohesh.
Mahishu.
Now, Lordship, both are the 2 different names of the same caste. But here also in this case, that the registered members of this society, whoever filed their application, along with the relevant document that we are belongs to Chasi Koibotro, which has been registered in the list of giving OBC certificate, but their application straightway rejected without compliance of the provisions of law. Because in terms of this government guideline, that is 2015, that if one application has to be rejected, that has to be upon compliance of the provisions of Civil Caste Civil Tribe Identification Act. Now, in the Civil Caste Civil Tribe Identification Act, it is clearly, Lordship, held that before rejecting any application of the OBC certificate, a hearing has to be given. But Lordship, I have annexed those examples, Lordship, that without giving any hearing, all these application upon saying one line that they belongs to Mohesh, so rejecting that day by day application. So Lordship, I am praying for before your Lordship say, Lordship, the clarification and Lordship, a detailed order which is be applicable upon the government of West Bengal, that such application which is proposed to be filed and already filed, that has to be dealt with in terms of the provisions of law. The first. And secondly, Lordship, the application which has been filed that they are belongs to Chasi Koibotto, their application cannot be straightway rejected on the ground that they are Mohesso, because there is no, Lordship, the iota of evidence has been collected by the inquiry officer that we belongs to Mohesso. Lordship, all these things, and Lordship, so far the Mohesso part is concerned, Lordship, state of West Bengal in an appeal before the Honorable Supreme Court has submitted a report that consideration of inclusion of Mohesso in the OBC category is under process. So also all these things has to be looked into by
the matter is connected with the Supreme
Yes.
So how this Honorable Supreme Court, the state government has filed an affidavit.
Maybe, but the Supreme Court directed
yes,
the
Lord,
court.
So this part also
Lord,
I am
my
not saying.
information is this, my instruction, Lord, very soon Supreme Court
Correct.
will pronounce the judgment.
I'm not today, I'm placing this writ petition only on the ground because of civil type, Identification Act, Section 7, clearly be held that before rejecting, a hearing has to be given. I am annexing orders after order that simply one line are rejected and be uploaded in the server. So this issue can take place.
When you will available?
Lord, 2 weeks, Lord.
2 weeks.
My affidavit in reply may be.
Lord, my affidavit may be taken on
Opposition.
opposition.
Affidavit in opposition filed by
My reply.
state.
Opposition
Yeah.
ta
Reply filed by the petitioner picked up in the record.
Lord, this is our opposition.
As per the prayer made by the counsel for the state, the case is adjourned. Let the matter appear on 3rd December.
May I prepare after 2 lots after SS? After SS lot. Any day lot, as your lot to come.
Don't know. Come on 3rd day, we'll see to that.
Lord, your lordship is pleased to fix on, Lord.
3rd December.
Lordship.
My lord, I appear, my lord, for the writ petition of my lord in item number 9.
My lord, in this matter, my lord, previous day, my lord, already fixed this matter 14 December. My lord, it is a scheme, my lord, incentive scheme, my lord.
Who fixed the matter on 14?
My lord, may I indicate, my
Who
lord, I
fixed?
appear.
My lord, this type of matter, my lord, several writ petition has filed challenging this incentive scheme, my lord. Affidavits are already filed by the state, and my lord, this is the last order.
My lord, this.
After, my lord,
My.
have a look.
My lord,
Matter
this writ
28
petition.
November, and my lord fixed this, my lord, another matter, my lord, 14 December, my lord, previously.
Now may I have my chance? if
That
my
matter.
other-
My lord.
Okay, let all the matter come on 14.
My lord, what I was saying is this application, my lord, the affidavits are complete. Kindly takes on record the affidavit in reply. Till such time, the challenge to that incentive, my lord, the grant of incentive, my lord, revocation act is, my lord, decided. No further, my lord, effective steps can be taken in this writ petition. So I'll wait, my lord, till that other issue is decided.
Okay,
by this court,
let the
and
all
thereafter-
application come together. Any application is pending.
No application is pending. This is only the writ petition. Kindly takes on record my reply, which is on time, madam. I have served the state.
Affidavit in reply filed by the petitioner be kept with the record. When it is submitted by the learned counsel for the parties, the analogous matters are fixed on 14th December.
My lord.
14th December, let the matter appear on.
Challenging revocation. My lord, there is another writ petition where, my lord, the same challenge is there. By the same petitioner, kindly also tax that writ petition, which is WPA 20155 of 2025.
When it is listed, then mention that.
Very good.
Lord, it is my application. Making the order passed by the directly connected with the secretary.
So it is to be released from here.
I appear for the respondent.
This court find that the matter is connected with the Surface Act. Accordingly, WPA 10425 of 2023 along with connected applications are released from the list of this court. with the liberty to the parties to mention before the appropriate court, having determination. Mention before the court. Yes, next.
That if I may brief it, the aspect on account for the petitioner, Mr. Shukri Guru has mentioned this matter in the morning, seeking adjournment on ground of Mr. Bhattacharya, Mr. Gaman Bhattacharya's senior counsel. He's down with 100.
Huh?
He's down with 102 people. It's already mentioned in the morning paper. Please to keep it as
Who is for the other side?
But I'm for the private.
What is the matter about?
the matter is about non-action on the part of ROC investigation to investigate into the conversion of a limited life conversion of a partnership firm, an unregistered partnership firm, into a company. Lordship, the records that were placed initially for the purpose of this conversion, prima facie there was no dispute made. But I have been held to be a partner of that particular partnership firm. It was done without my consent, whereas the Companies Act itself mandates that consent from each and every partner has to be obtained, which was not taken. Lordship, purportedly by creating fake documents, some other people were shown as partners, and this company was converted to a private limited company. Tightening of all accounts.
Okay. Ready?
Lordship, I am ready, but
क्या कहा? फाइल नहीं है. So I am adjourning the matter.
Very well. Whenever your lordship pleases.
Come on, third. Huh?
We have filed it.
As per the prayer made by the counsel for the petitioner, case is adjourned. Let the matter appear on 26th. 26th.
But my lord, one humble prayer, my lord. Any date, my lord, apart from 26th and 27th, my lord.
26, 27.
Prior also, my lord, any date. We were anyways, my lord.
25.
25. Grateful.
अरे इसको चेंज करो यार. Yes, next. क्या हुआ? नहीं है, फाइल नहीं है. Call the matter. Item 13 is there. Item 13 record is there. 12 is not there. Item number 12 file is not there. Item number 12 pass over. Call the item number 30.
I have the state respondent lordship in this matter, my lord.
So far, the last order, 18th of September
18 September. File let the affidavit novice file 4 weeks. Reply December 2023. No affidavit filed. Yes.
No, my lord. No, my lord. According to us, my lord, now this matter became infructuous. Why? Lordship kindly comes to page 176 once.
Even if it is infructuous, then count the affidavit. What prevented it?
176.
Lordship, kindly see, my lord, kindly see the impugn portion after careful consideration.
যেটা 176
lordship এটা 176 oh my 170, just a second, Miller.
176.
Yes, the improved order, Miller. No, 171. I'm sorry, Miller. That's difficult to.
Yes.
After careful consideration, we'll kindly go through this once, Miller. Lordship will find, Miller, fact that the concluded that the petitioner company was applied for RC2 acknowledgement so and so as per para 5.3 of the so and so. The unit shall be required to submit application in the form of so and so within 30 days of commencement of commercial production thereafter. In the present case, the company has started commercial production at least from October 2018 but submitted their application online on 6/5/2019. This is with regard to the eligibility criteria. Now, my lord, this incentive scheme which they have intent to short for is, my lord. Now, my lord, there is at the present moment, my lord, the scheme which has been challenged before his lordship, my lord, in this writ petition, my lord.
No, not.
Oh, not. Oh, my lord.
This is a separate scheme.
Okay, it's a ball. A portion of our.
Free.
No, affidavit will come later, my lord. First, lordship, if ball ki bolche?
এই যে নতুন স্কিম
Several matter, my lord, 2025, my lord, act came before your, my lord, several writ petition challenge this act, my lord, incentive scheme. My lord, previous, my lord, 14 December, my lord, several matters, my lord,
this
Yeah, my lord, they have not challenged.
this has not been challenged.
Not at all.
May I assist?
This is
Lordship?
not under challenge.
This
No.
is not under challenge.
Yes.
This has become infructuous
Because of coming into that.
due to this
This act, this presence of this present act, my lord.
present act of 2025, which clearly says clause number 3, Lordship.
Just
Clause number 3 of the
clause 3, my lord, of the act, my lord. Hey, Joseph, to din to eta. Babu.
Have you gone through? Go through.
This act.
No, affidavit will come later, my lord. Lord, kindly see clause 3, my lord. Notwithstanding anything to the contrary contained in any other law for the time being in force or in any schemes, grants and objections or contrary agreements or promise so and so, the West Bengal incentive scheme set out in the schedule and all kinds of incentives by whatever named called contained in the grants or obligations or contracts or agreements or promise are hereby retrospectively withdrawn. So, my lord, this now he has to apply it with challenging this scheme, not this one.
So you have two options. Either you go through this act.
Yes.
I will go through the act. My lord, the contention of the point they have raised while rejecting my application was that we have started commercial.
Now that has come after this act.
That's in the scheme itself is there. I will show it from. Let them deal that scheme. Let them file an affidavit.
But there is no question of filing affidavit, my lord.
They have to.
No, I will record their submission. They don't want to file the affidavit in opposition. They are relying upon the
the existing act.
This is
This is everywhere is there. It is on record. It is on record, my lord. It is on the website.
You are having two options. Either you go through or this application will be taken up along with the other application wherein
that would be better, my lord.
Let them supply me that.
Yes, supply.
That is that I will. It's online, my lord. Everything is online.
It is on.
Let me go through that.
Go through. I am fixing after 2 weeks.
Yes.
Go through.
Along with those matters,
suggest because there are several matters.
Other matters, my lord.
No, this act is under challenge.
That's what.
If you want this, maybe your application, if it accepts.
At all applicable with
Okay, you go through. The counsel for the state respondents submit that after the what is the act it say?
A lot of 684.
I mean, I just tell you, lordship.
What is the act name?
My lord, just a second. It's named, my lord.
West Bengal.
West Bengal revocation of West Bengal incentive schemes and obligations in the nature of grants and incentive act 2025. It's a long.
Have a look this order.
Forget it.
अरे बेटा ऑर्डर दी तो अरे ऑर्डर दो ना यार
Give both.
क्या बोला? Submit that No affidavit is required to be filed in the present. Affidavit in opposition is required to be filing in the present case due to the implementation of the revocation of the West Bengal incentive schemes and obligations in the nature of grants and incentives Act 2005. Counsel for the petition press for time to go through the said act. Select and press for time. In view of the submission made by the parties, the case is adjourned. Let the matter appear on 3rd December.
Lordship, grateful, Maharaj.
फाइल आया नहीं मिला. Not filed affidavit.
Not filed, my lord. Not filed affidavit, my lord. Kindly have a look this matter, my lord. Itself, my lord. If my lord is not satisfied, then my lord we will file these affidavits, my lord, within 2 weeks, my lord. My lord, kindly.
No. If you want
My
to
lord,
file
my lord,
affidavit,
within 2 weeks,
or
my lord,
otherwise
kindly.
I will hear the matter, dispose of without the affidavit.
My lord, kindly, my lord, 2 weeks, my lord, extension.
Why
2 weeks.
you persons are not 2023 matters?
My lord, knows.
Because if the lordship also takes up one order,
Yes, there you go.
2023 also, the order prior to the order for directions able to also disclose the rules.
Let the disclose. The learned counsel for the state respondent prays for extension of time to file affidavit in opposition. Let affidavit in opposition, time to file affidavit in opposition is extended for a further period of 2 weeks. Reply, if any, there to be filed by. Reply 1 week. 1 week thereafter. This is the matter. On 17th December.
Month.
Call. Password. Call the password matter.
Oh.
Lord, my application.
Affidavit filed.
No, there's no affidavit by the respondent number 1. The respondent number 2 is filed in affidavit. If your lordship is in the last order, there was a direction for filing of an exception by not the private respondent. That exception has not come to my supplementary affidavit. And
I'm appearing on behalf of respondent number 1. Mr. Ghatak is appearing on behalf of West Bengal Clinical Establishment Regulatory Commission. He's not in town, my lord. So, Mr. Ghatak. My lord, kindly.
may I file the supplementary affidavit, Lord?
My lord, I'm appearing for respondent number 2, my lord.
Served to copy.
Yes, everything's been served.
Yes.
Exception was supposed to be filed by respondent number 2 being the private respondent.
My exception is only by the private respondent.
Filed.
Not filed.
Who is for the private respondent?
My lord, my senior is on his legs before some other court, my lord.
The exception.
My lord, I'm not aware of this. My lord, my senior is on his legs before some other court, my lord. If a short password maybe.
Taken the instruction, whether you file the exception, otherwise you will record the.
My lord, affidavit of opposition has been filed.
Otherwise, I will record. You will not file exception. Then let the report be continued.
My lord, if a short password, kindly make it.
What short password? Then he already asking for. She is also asking for time. Counsel for the petition submitted. In spite of the order passed by this court, the private respondent has not filed exception. Full stop. The counsel for the respondent state.
Clinical establishment.
West Bengal Clinical Establishment Regulatory Commission.
Counsel for the respondent number 1. Raise for time. According cases at the petitioner has filed a supplementary affidavit after serving the cooperative counsel for the respondents. Let the same be kept to the record. This is the matter on 3rd December.
Grateful. The respondent, there's no direction upon the respondent number 1 to file an exception.
My lord, respondent number 1 may be given liberty to file the opposition, my lord, because my instruction is that we have not filed opposition.
Well, 2023, the
direction, but you are not filed.
2 years have passed.
Direction to file opposition, but the opposition has been filed by respondent number 2.
My lord.
So, if my lord, we can also file an
No,
opposition.
direction was given, my lord, in 2023.
Will kindly seize, my lord, 12th of May 2023.
Is there operating, my lord, but
This is the order which was passed initially, and thereafter, my lord, the matter has appeared at least thrice. They have never sought extension.
orders in total, my lord. The first order granting stay.
Lordship, 4th August 25. This is the order where, my lord, the respondent number 2 filed their affidavit. We filed a reply.
But there is no direction upon.
No, my lord.
No,
Lordship will kindly see 4th August, my lord, 25.
4th August. Yes, 4th August 25.
My lord,
Only
the
two filed.
only 2 filed. Well, they have not even come prepared with it, my lord.
My lord, if within
Well,
that
there is
time frame,
there is any direction upon
No, my
the
lord.
there was
Not recorded.
counsel for the respondent number 1 press for time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks. Reply if any there to
Within 1 week, my lord.
a week thereafter. So 10 तारीख 3 तारीख बोला ना 3 तारीख को आ गया 10th December. 10th
The third of the 10th of December, my lord. Very good.
great.
My lord, my lord, I have just received instructions from my senior, my lord. We will not be filing the exception, my lord.
पर एक जगह बोला ना not file the exception and submit that he has instruction not to file exception.
Grateful, my lord.
Grateful.
Lordship, in this matter, Lordship, Mrs. Anjona Banerjee is appearing for the Mrs. Anjona Banerjee is appearing for the petitioner, Lordship. She is out of town, Lordship. I mean, Mrs. Anjona Banerjee. I mean, instructed to pray for accommodation for fortnight, Lordship.
What is here? Advocate is out of town. What will done? You argue?
Lordship, I am not
My
aware
lord,
of
in this,
the
my lord, in this
Lordship.
matter, I'm appearing for the respondent number 2, my lord. My lord, humbly praying for a direction. My affidavits, my lord, fortnight's time, my lord, 2 weeks, 1 week, my lord. Because there was a direction for affidavits, there are certain subsequent events which has happened, my lord, and there are certain issues involved in this writ petition, my lord, which are also before the Honorable Appeal Court, my lord. So, my lord, if my lord kindly, my lord, directs me, my lord, to file an opposition, which the respondent number 1 has also not filed, I presume. So, within a period of 2 weeks, and my learned friend files a reply 1 week thereafter.
Counsel for the respondents press for extension of time to file affidavit in opposition. Time to file affidavit of opposition is extended for a further period of 2 weeks. Reply, if any, there to be filed within a week thereafter. List the matter on 17th December. Next.
My lord, in this matter, I'm appearing on behalf of the respondent number 4 board, my lord.
Who is for the petitioner?
Your Lordship, appearing on behalf of the writ petitioner.
My lord, in this matter, my lord, before petitioner starts, my lord, I just want to place before your lordship, my lord, the order was passed in 1 century plywood, my lord, wherein, my lord, the veneer and plywood was not covered within the parameters of agricultural produce. My lord, there was 2 amendment, my lord, which was not considered in that. That is pending in appeal. Now, my lord, in the meantime, the 2 amendments, 2014 and 17 amendments were under challenge. A coordinate bench has held that this is not ultra virus, and that was subsequently there was an appeal out of that. There also, my lord, the court held that whatever is the fees payable, my lord, that would be paid subject to, my lord, the result of the appeal. My lord, may I just hand this orders to your lordship? And my lord, in a similar matter, challenging that only, my lord, Justice Amrita Sinha has also held that this is something where, my lord, they will be paying. I'm just handing over whatever will be the charge, my lord, and this is the order of the appeal court, and the order wherein, my lord, it was held ultra virus was shut down. It was not ultra virus. Well, this is the order which I was referring to. It's, my lord, under West Bengal Agricultural Produce Marketing Regulation Act. So there was 2 amendments, my lord, one in 2014 and one in 2017, based on which, my lord, the definition of agricultural produce was, my lord, changed. Now, my lord, that was not covered in century plywood. So that was the thing, my lord, which was subsequently clarified in all this.
Green player order.
And annex করা আছে।
My lord, that is one of the reason, my lord, we could not file our opposition also, my lord, although there was a prior direction to file our opposition.
Yes.
Your Lordship, the situation in this matter is a little different than what my learned senior friend has submitted, Your Lordship.
What is your prayer here?
My lord, my prayer in the writ petition is that plywood and veneer are not agricultural produce under the Act. It has already been held so in the judgment of Century Plywoods. There have been amendments to the main Act, to the parent Act. That is, there is no dispute about the fact that there are amendments. But there is also a notification of July 24, 2017, which reintroduces plywood and veneer as an agricultural produce. And that operation of that particular notification has been stayed by the Honorable Court.
Yes.
My lord, kindly seize your last order.
What you prayed for before this court? What is your prayer in the present writ application?
My lord, the notification, we have challenged the notification.
Then,
My lord, the here in this particular case, which my learned senior friend is relying on, Setia oil is on the virus of the amendment.
correct.
My lord, the virus of the amendment has been said that no, it is not ultra virus. The amendments are not ultra virus. And that particular matter was also in respect of rice bran oil. It was not in respect of whether plywood or veneer can be added, because plywood and veneer, whether they are agricultural produce, that has already been decided by this Honorable Court in Century Plywoods, that they are not. They reintroduced it.
So your submission is that the judgments which the petition right?
No, it has no bearing on this matter. And secondly, Your Lordship, well, there is already an interim order. Interim order that no market fees will be levied or imposed or collected from the petitioner till disposal of the writ petition.
Correct.
They have not come up with any order for vacating. They have not challenged that order. They have neither filed their affidavit in opposition. So I'm only seeking, let them file these.
Whether you file affidavit?
Yes, let them
No,
file
no, my lord, we
affidavits.
did not because of this change of circumstances.
They is telling that that notification is not concerned with the.
Yes.
My lord, 1 minute only. My lord, kindly comes to page 27 of their brief, my lord. That's the prayer.
Division bench order.
My lord, their brief, page 27. My lord, it starts from 26 prayer day.
Yes.
May I just read? A writ of and/or in the nature of and/or direction in the nature of mandamus restraining or forbearing the respondent's authority and each one of them, their men, agent, servant, and/or assigns from imposing and/or levying market fee on petitioner number 1 for sale of plywood and veneer and from giving any effect and/or further effects to and/or act on the basis of and/or in furtherance to the said notification dated July 24, 2017. So, my lord, this is the one which is pending before the Honorable Division Bench. Now, my lord, kindly
not in
turn to
Setia
page
Oil's case.
25.
Not in
My lord,
Setia
kindly
Oil's case.
Might be notification,
This
but whether in that.
My lord, one
notification was not challenged.
My lord, may I just
No,
say,
it was not.
my lord, one notification where, my lord, the definition of agricultural produce at was taken in and in rem it was changed. My lord, it became, my lord, initially the definition was, my lord, which is set out in the old act. My lord, if I may read, my lord, it was old act definition of century play. My lord, may I read the new definition, my lord? That is which was affected with effect from West Bengal Agricultural Produce Marketing Regulation Act. Just let me hand over the book to my lord.
না আমি দিয়ে দিচ্ছি আমার কাছে আছে
আছে? My lord, it becomes agricultural produce. Your lordship has got the book.
No.
My lord, may I?
আমি তো সবকটা পাঠিয়েছি কতটা থাকবে দেখ দে
এটা পুরনো বই?
Your Lordship, these are the amendments, my lord, that have taken place.
You have the amendment?
আমাকে একটা দে
My lord, kindly sees there was twice the definition changed. My lord, in 2014, it became agricultural produce means any produce, whether processed or unprocessed, of agriculture, horticulture, apiculture, pisciculture, sericulture, livestock and products of livestock, animal husbandry, feces, raw wool and skin of animals, forest produce and any related and secondary product or byproduct and combination of two or more than two of such produce as specified in the schedule. So my lord, the entirety was put down in the schedule. So the moment they challenge that particular notification, it covers everything, because my lord, that is something which was under challenge, and that they had actually challenged the virus, which actually was not spelled out in the prayer, my lord, is configuring from page 25 of their brief, my lord. Kindly see page 25, the last ground.
We have not sought for any
My lord,
declaration
can
of
you see
ultra
one of
violence.
their ground?
Our writ petition
Last prayer is ground is for that the impugn notification is otherwise ultra virus, arbitrary, illegal, perverse, and is liable to be quashed and set aside. So, my lord, this is also one of their ground as to why they are challenging this. In actual unambiguous connotation, they have not spelled out ultra virus in the prayer, because that would have created certain other predicaments and certain other parties were required to be added. That is what they did not do. But what they did instead, my lord, in the ground only, my lord, kindly see first ground in that particular page is that they have challenged the definition agricultural produce. For that, plywood and veneer cannot be treated.
Yes, your lordship, but we have mentioned that as one of the grounds.
Yes.
Violate that.
Not one of the ground 17. Can you see the ground 17? For that, the plywood and veneer cannot be treated as agriculture produce within the meaning of section 2.
Yes,
Decide this, my lord, your lordship.
Reason, my lord, that is my principal challenge in the writ petition, that once
let the matter go out of the list to the disposal of.
My lord, much
let them file their affidavits in opposition, your lordship.
My lord, they are enjoying the interim order. I am not yet filed.
If the division bench held, here it is a
Yes,
virus
my lord.
automatically. If it is not, then they will.
My lord.
Nothing remains in that.
Absolutely, my lord.
Nothing remains.
The
Because
only
my lord, we are in a
here-
situation where either it will be there or it will not be
only
there.
distinction is that
Now one single judge has held, it is not a ultra virus.
Yes.
Division bench has held, yes, it is. Let it be pending.
it
Then
is
you pay
pending.
the amount till the
Absolutely.
subject.
I bow down to your lordship.
Now you got the interim order from this.
Yes, yes,
The
your
interim order is still the disposal of the case.
Yes, your
Let
lordship.
them go out of the list for the time being. Liberty to mention.
And my lord,
The appeal
century
court, when the appeal court will be decided.
Why?
Yes, yes.
Liberty to mention.
Yes, your
and century plywood, my lord, based on which they had filed this rate, that is also under challenge before the appellate court.
lordship. Not only that, there are other findings of the coordinate benches also.
It is submitted by the Learned Counsel for the state that the notification dated 24th of August 2017 and 24th July 2017 was challenged before the court in a writ proceeding in WP number 17846 within bracket W of 2012 and WP number 11513 within bracket W of 2019. And this court has held that the notifications is not an ultra virus. Being agreed with the said order, the writ petitioners of the said writ petition have preferred an appeal, and the appeal is pending. It is submitted by the party that the petition is enjoying the interim order till the disposal of the case. As the subject matter is pending before the appellate authority and the petition already enjoying the interim order in the present case, accordingly for the time being, let the matter go out of the list, liberty to mention after the appeal is disposed of.
Much obliged.
Only, if your lordship so pleases, my lord, only records the submission that the judgment relied upon is distinguishable on the facts. That is my submission, your lordship. Kindly records to that effect.
What?
Oblige, your lordship.
Why you want?
Much obliged, your lordship.
Okay, thank you.
Oblige.
Rather, boy.
Of the present date application. Of the present date application, accordingly, let the matter go out of the list. Yes. Yes, who is appearing for the petitioner? Item 17. None appears on behalf of either of the parties. No accommodation is sought for. For the interest of justice, case is adjourned. For the interest of justice, the case is adjourned. Let the matter appear on 17th December.
In this matter, I am appearing on behalf of the petitioner, my lord. A copy of the opposition has been served. Lordship, I am paying for some time. A copy of the opposition has been served. Lord, I could not file the reply, my lord. I am paying for some more time, 2 weeks time to file reply, my lord.
Who is for the respondent?
Previously also none appeared.
None appears on behalf of the state respondent and respondents. Counsel for the petitioner. Press for time to file affidavit in reply. Let affidavit in reply be filed within 2 weeks. Release the matter on 10th of December. Next.
Get pretty lords. 19 melons for the petitioner.
Number 4.
Well, it's for the petitioner. Similar prayer melons. We have not been able to file our reply. Kindly grants us 2 time. AO was received on behalf of respondent number 6 to 17.
You are appearing for?
Respondent 4. I have filed an application for recalling of the order.
What order?
That, my lords, his crux of the application is by virtue of
September 2023.
I would like to file an opposition to it as well, because in essence, if my lord peruses the last day's order passed by the then Justice Honorable Nizamuddin, he had asked us to implead the medical council as a party.
Our case is we are before impleading the medical council. Honorable Justice passed some order against us. And
well, it should
we have filed
kindly
an application.
peruse the order. The order which was passed against them purportedly was merely for considering my representation insofar as the negligence of doctors are concerned. The writ petition is regarding negligence of the clinical establishment. So now they have come up with a CAN application saying my complaint is not in the proper form.
Yes.
I need to deal with it, my lords, possibly, and to check and take instructions that whether my complaint indeed is not in the proper form for them to pass any order.
Legal counsel. Proper application
Yes, you filed the affidavit. Have you filed the affidavit?
No, we have filed an application.
Who are you?
I am for the West Bengal Medical Council, statutory body.
Added respondent.
Added respondent.
Yes.
Number 8.
Now,
so you filed you have already passed an order.
That's why you have filed an application in view of the fact.
No, you please hear the court first.
Yes.
Then you make the submission. You pass an order.
We have not passed any order.
You have not passed any order.
They have filed an application repentation, but the repentation is not in accordance with the rules.
Okay, come with an affidavit. Come with an affidavit. Why the deletion?
But see,
why you're afraid to appear before this court?
No.
Then why the deletion? When the court has already impleaded you, why the other court can?
Before impleading, the court has passed order. Now, if I don't file this application, we can subject to a contempt application. Before we impleading, the court has passed against us. We kindly ordered the 19th September.
Correct. I have gone through the order. The court has of the view that the complaint which he has filed, you have not taken into consideration, not passed any order, and directed you to complete the process.
That's why we have filed an application since we have not made party at that relevant time.
Correct.
Subsequently, pursuant to the reaction, we have made party. And
so have you complied with this order?
No, I have to take instruction to that effect.
So without compliance, you wanted to the order is to be recalled.
That's why you have filed an application. We have not made party before considering that application. The petition cannot be considered by. We have to go through by the rules and act.
Correct.
So,
you do that. Court has directed you. Kindly come to the page 15 of your application. Second line, the authority, you read the authority.
They have made a representation is 114, page 114. That is the representation made to the Legislative Medical Council. So as per the rules, kindly,
Sir, you disclose all the thing in your affidavit in opposition. I am dismissing this kind of application. Why you are wasting the time of the court? You file the affidavit disclosing all these things. What do you want to say? Your authority has not been directed to appear in person before the court. Then,
we have
the respondent number, added respondent.
Added respondent number 18.
Added respondent has filed the present application being CAN 1 of 2023, praying for recalling of the order dated 19th September 2023, wherein this court has directed the petitioner to add the added respondent in the present case. The counsel for the added respondent submits that the petitioner has made a complaint before the added respondent, but that is not in accordance with law.
according to the rules.
In accordance with the rules, and without giving any opportunity of hearing to the added respondent, this court has added the respondent in the present case. Consider the submission made by the counsel for the petitioner. Peruse the order dated 19 September 2023, wherein this court also was of the view that as regard the allegation of the medical negligence is concerned, the petitioner has already filed a complaint to the West Bengal Medical Council, and the said complaint is appearing at page 168 of the writ petition. And this court has directed the concerned authority to consider and dispose of the aforesaid complaint of the petitioner dated 28th of February 2022 in accordance with law by passing a reasoned and speaking order after giving an opportunity of hearing to all the interested parties or the authorized representatives within a period of 12 weeks from the date of communication of this order. Considering the above, this court finds that this court has added the respondent and pass certain direction as pass certain direction. If the added respondent has complied with the order, the added respondent can file affidavit in opposition by disclosing the reasons if the representation is disposed of, if not disposed of, to give the reason why the representation has not been disposed of in terms of the order passed by this court. In view of the above, this court finds that the application filed by the petitioner being CAN 1 of 2023 is misconceived and according same is dismissed. As when you file the affidavit in opposition, let affidavit in opposition be filed by 3 weeks. Reply, if any, there to be filed within 2 weeks. Thereafter, list the matter on 17th December. File.
Only one prayer. I also need an extension to file reply to the main AO of this writ petition.
Main, I am filing now. Can dismissed.
No.
The main AO.
Main AO has already been received by me. Probably that is not it.
Another.
No, none of them are that party.
So that's why I directed to file affidavit.
Okay.
File affidavit.
Lord, in this matter, I am led by Mr. Ronilban Banerjee. I am led by Mr. Ronilban Banerjee, Your Lordship. We haven't received any affidavit in opposition till date.
Without affidavit, you can argue the matter.
I appear for civil.
They will, if they are not ready to affidavit, you argue the matter. It is your writ petition. Why you are taking the burden of the other not file the affidavit?
My learned senior. But my learned senior asked
not to take the shoulder of the other person, sir. You come with brief with your shoulder. Why you are keeping your brief in the other shoulder?
But I appear for civil. Respondent number 2.
CBI.
Civil.
Civil,
Mainly, our submission is a civil suo motu cannot make any correction or deletion or alteration without the instruction from financial institution. But as per instruction, whatever record we received, we have made to that effect correction. That's
So you will not file affidavit.
as per instruction, my lord. If my lord may permit, then I can.
Why the my lord will? If you want to file affidavit, you file. Otherwise, I will hear the matter without the.
But,
Already there is a direction, but you not file the affidavit.
respondent number 1 is not present. Who is the credit institution?
Who is the respondent number 1?
Credit institution company.
Huh?
Fullerton India Credit Company Limited.
Correct. And you are?
I am for the civil. Respondent number 2.
2.
Yes.
Who is for the 3? Have you served?
Yes,
Have you served? Where is your affidavit of service? Where is your affidavit of service?
In that case, your lordship, kindly fix a small short date
for. There are altogether 5 respondents, 4 respondents, and she is appearing for the 2. On the last occasion, somebody had appeared for 1. What about the 3 and 4? Counsel for the petitioner placed for time to file affidavit of service. Let affidavit of service be filed within a week. Please the matter on 26 November. Next.
I am appearing for the Steel Authority of India, my lord. May I be permitted to file my affidavit in opposition, my lord? Respondent
My lord, for the petitioner, my lord, Mr. Shomi Ganguly is appearing in this matter. His father recently passed away, my lord. His father recently passed away, my lord. He is out of station. I am praying for not this week, my lord.
How many respondents are there?
My lord, the answering respondent is respondent number 227, and Union of India is also there, respondent number 1.
You are appearing for?
227, my lord, Steel Authority of India.
Have you received the affidavit?
Yes, I have served, my lord, on 30th July 2020.
227. What about the other? Two to 7.
My lord.
Only 1 is not appearing.
1 is not appearing, my lord. Union of India.
Respondent number 227. File the affidavit in opposition after serving the copy to the counsel for the petitioner. None appears on behalf of the respondent number 1. Counsel for the petitioner prays for time to file affidavit in reply. Let affidavit in reply be filed within 2 weeks. This is the matter on 3rd December.
Wait.
Very strange writ petition.
Yes.
Which emanates out of stranger events. Lord, I am asking that a writ of mandamus be granted, directing steps under the PMLA to be taken by the Enforcement Directorate against my brother. And more particularly against some of his assets. These, Lordship recalls the suit, Ramesh and Mahesh. Now here what had happened was, the private respondent, Milord Mahesh, he, Milord, had devised an ingenious, Milord, strategy. He went and he got certain LIC policies. Now these LIC policies, you have to pay premium every year. So he paid the first year and he got the policy. He, his wife, his son, everybody. After getting those policies, on the strength of those policies as security, he got money from certain nationalized banks. After that, he defaults. He doesn't pay either the policy, neither does he, Milord, pay the bank. Bank, Milord, there's huge outstanding to the bank. So, Milord, ultimately, there is a CBI case, Milord, which is started. CBI case, charge sheet also filed, Milord, that this is the ploy. You open a policy with 1 year's premium, then you don't pay further, and using the full value of the policy, you get security from nationalized banks. So I am happy. I am not on good terms with him. I am happy. Now ED proceeds after him. When ED proceeds after him and Milord attaches by provisional order of attachment his assets, he goes and tells ED, and the ED attaches shares which he held in my company and land in my company, which, Milord, under a family settlement had come to me. None of his other assets, Milord, are touched. I, Milord, move a writ petition, and I have obtained, Milord, interim orders protecting me. That's another matter. Against, Milord, those that PMLA order of provisional attachment. My argument there is, Milord, simply this. He has no right in my company. He had 500 shares, his own share for 700 shares, his own shareholding. Company Law Board has said that has been validly transferred to me. He's filed a Section 10F appeal. He hasn't got any order. His wife's shares are, Milord, minuscule, maybe some 500 shares. So A and B shareholding, Milord, doesn't give him any, Milord, real right in the company, because under family settlement, it's come to me. Number two, assuming that this argument fails, shareholders only have a right, shareholders have no right in respect of assets of company. Only shareholders' right is to receive dividends and to vote. Now, but the ED, Milord, not without using this sensible logic, proceeds to, Milord, attach the land owned by this company and wants to proceed against, Milord, the company. That, Milord, is a subject matter of a separate, Milord, writ petition. I am enjoying interim orders. Now, this writ petition I have filed on the ED, saying that he has, Milord, several companies, he has several assets, he has, Milord, that Parijat Vyapar, which has huge turnover. You have ignored all of that. You have only, Milord, proceeded to attach a company where this man has literally no rights. So this is a wrong act on your part. You immediately proceed to attach his own assets. And then that will help me also to get my asset free. Now, Milord, if your Lordship, we served. Yes. Milord, on the first day, I had said, Milord, there is no scope for any ad interim order. Please direct affidavits. Kindly see the affidavit of service, Milord, page 4. This is the first order. Third paragraph, Milord, is my concession at the ad interim stage and directions to file affidavits. Now, kindly, Milord, see from page 6 onwards.
How many different respondents are there?
Milord, 11 respondents.
7.
1, 2, 4 were, Milord, are, Milord, Union of India and ED.
4, 5, 6, 7, 8, 9, 10, 11. They have appeared. On the last September 2020, they have appeared.
Yes.
5, 6, 7, 8, 9,
Yes,
10,
yes,
11.
4, 5, 6 had appeared. ED hadn't appeared. We've served them.
ED is dependent respond number.
ED is, Milord, 2 under 1, but 2 and 3.
2 and 3.
2 really, Milord.
2 service affected. Director, deputy director.
Milord, please see page 5 at the top.
Deputy director.
Milord, page 5 at the top is the postal slip to ED. Please see deputy director, Kolkata zone ED. And the number, Milord, ends with 2750 IN.
758 IN. Yes,
So, Tamil-
page 7.
Yes, yes.
Page 7.
Yes. No affidavit filed by anybody.
And what about
Now, my lord, may I show your lordship
3?
the charge sheet at page 80 before the learned special judge?
So why the writ petition? Why you not file an application before the special judge? Why the writ petition? If the charge sheet is filed and the
No, this is, my lord, the predicate offense.
predicate offense, no problem.
I also want them to proceed, my lord, under the PMLA.
Correct. Once the PMLA charge sheet is filed before the concerned court, and you find that the investigation is not and you are the complainant. You are the complainant in
No, no.
You're not
The banks are the complainant, I
banks
think.
are the complainant. You are not the complainant.
No, no, I'm not the complainant.
The case which is pending before the
I'll just see who's the
complainant in the suit in the case.
my lord, it's CBI, my lord, is the complainant.
CBI might
On Allahabad Bank's complaint.
Where is the charge sheet?
Please come to page 80. আমাকে না উত্তর দেবে, don't keep on saying something, আমি গুলিয়ে যাই, just answer টা দাও, এলাহাবাদ ব্যাংক কোত্থেকে পাবো, show me that. I have actually no axe to grind.
Who is the Indra Kumar Agrawal?
Sorry, Milord. Yes, Milord. Indra Kumar Agarwal, Chief Manager, Allahabad Bank. Page 86, paragraph 16, subparagraph 1. Allahabad Bank made this complaint.
Okay. Yes.
Now, my lord, please kindly come to page 87. Result of investigation. But during investigation, it is revealed that Allahabad Bank is the corporate agent of LIC as per manual number such and such. The then senior manager was specified person for procuring LIC policies on behalf of Allahabad Bank, and commission was earned by the bank. On the other side, Sri Anindo Guho was the financial service executive such and such. Then next paragraph. Mahesh Kejriwal and Alka Kejriwal purchased LIC Market Plus policies for 16 lakhs each, and documents were made available to them. They opened a bank account. Then, Milord, middle of the paragraph, they said LIC Market Plus 1 policies were assigned by LIC in favor of Allahabad on the request of the policy holders. It is pertinent to point out that LIC in the letter dated such and such informed Allahabad Bank that the assignment of the policies were done in their favor. It was further informed in the letter that LIC does not make any admission, etc. Then, Milord, further it may be noted, LIC policy bond mentioned that no loan will be made available. Now, kindly see the second last paragraph. LIC had quoted, my lord, the surrender value. Then, page 89 are the loans which the private persons, that is, my lord, Mahesh Kejriwal, Siddharth Kejriwal and Alka Kejriwal took. Page 89, your lordship would find, my lord, that they took 22 crores.
Who normal appears for the ED?
Oh, Mr. Orijit Chakraborty, I can tell him. Now, after that, no pilot premium was paid. As a result, the bank was seriously duped. He ran away with 22 crores. Now, I am okay, Milord, with that. It's a matter between bank, CVI, ED and him. I don't want to be involved. But when ED issues order of provisional attachment, ED mysteriously leaves all his assets aside, all his companies, and comes after my company. Which is why I went and filed a writ petition, got that stayed, and I have filed this writ petition saying please proceed against him and attach his assets.
What is the prayer?
22 page 22 my lord. Take steps and initiate process under PMLA against respondent numbers 4 to 11 and other assets and companies of respondent numbers 4 to 6. Because once, my lord, their assets are, and I've given particulars of their assets also. Once their assets are attached, my life becomes easier to get mine out.
Okay, you issue the notice to the appearing counsel.
I'll give him better to do it in their presence. my lord.
That is better. That's what is their say.
Yes, yes.
Let them take instruction.
Because there can't be, my lord, any logical reason if my lord, if I have clean asset and you are the investigating agency wanting to proceed against me, then there is no, my lord, reason not to proceed against the clean asset and proceed against some asset which is, my lord, disputed.
The petition has filed affidavit of service. Let us same be kept with the record. In spite of service of notice, none appears on behalf of the petition respondents. This court find that the application is to be heard in presence of the respondent number 2 and 3. The petitioner is directed to inform the next date of hearing to the learned advocate who is appearing for the respondent number 2 and 3. This is the matter on 26th November. Come on, 26th.
But with the lordship's kind leave,
Affidavit of service.
writ petition pertaining to my lord's determination.
May it be 27th.
Writ petition pertaining to my lord's determination, along with an application for anticipatory bail, my lord, was being taken up by the Honorable Justice Amrita Sinha. Now, the difficulty is, my lord, in the anticipatory bail, there is an interim protection order which is expiring today. The matter was listed, my lord, but her ladyship is of the opinion that it should be listed before your lordship because no, the writ petition, because the assignment order says that to be heard along with the let CRM such and such be heard along with WPA number such and such by the honorable bench taking up WPA number such and such. So, my lord, it's a very serious matter, pertains to, my lord, issuance of forged birth certificates, death certificates, getting illegal immigrants. This person is basically a whistleblower. He was working as an election enumerator. There was force and pressure exerted upon him by the superiors, and he has brought it to the notice, my lord. So, criminal case also regarding which the anticipatory bail is pending, and regarding the writ petition, there are already directions, my lord, passed on the ECI. So, if my lord may kindly, my lord,
you are appearing for whom?
But I am appearing in the writ petition, and Mr. Saurabh Chatterjee is leading Mr. Nag in the anticipatory bail, my lord.
For the petitioner.
For the petitioner.
Who's for the state?
State Mr. Vivekananda Bose, my lord, I have informed him that we will be mentioning it before your lordship. Yes, he was there in the morning.
Assignment order?
But this pertains to
Which one?
Which one? I'll just tell you, lordship. The last but 3, Orun Gorai.
CRM terms to be heard along with the WPA. So this WPA 121 is pending here?
Yes, it is pertaining to my lord's determination. It's a non-police residuary.
So what do you want now?
My lord, may kindly, my lord, take it up at 2 o'clock because the interim order, the protection in the anticipatory bail, is expiring today.
Today?
My lord. And the police, my lord, they are, since he has brought it to the notice.
I don't know how the record will come.
No, her ladyship has directed that since I am releasing it, it should be placed before your lordship's bench, my lord, today itself.
ये matter ना supplementary list निकालो 230.
Notice दिया तो विवेक क्यों?
230.
230. Extremely grateful, my lord. There is a resolution I find, my lord, today at 2:30.
2:30.
Yes, there's no, from 2 there is a resolution and not to take up in the absence of parties. I'll still, my lord, issue a notice to Mr. Bose, my lord, Mr. Vivekananda Bose. He is here also.
2:30.
2:30. Grateful to your lordship.
Supplementary list, huh?
Extremely grateful, my lord. Calcutta.
It has been repaid.
I am appearing for the financial institution, Aditya Bila, my lord. I have instructions of the matter. The matter has been settled, my lord.
Can I record the?
Yes, my lord.
Matter is settled.
Don't record my.
Huh?
Yes, my lord. Let it be.
Where is-
I will put it. Paper.
Where is that settlement paper?
No, not.
My lord, that is not on record. That is not on record.
Already taken place during the pendency of the matter.
So can I record?
Yes, my lord.
Yes, my lord.
My lord can record.
Yes.
It is submitted by the counsel for the respective parties. The claim made by the petitioner in the present writ application has been settled and thus nothing remains in the present application. Counsel for the in view of the submission made by the counsel for the parties, the WPA number 16424 of 2023 along with CAN number 3 of 2023 is dismissed as infectious.
Obliged.
If you prolong the bill, so after 6 months, I'm coming. Just
Huh?
2 weeks time,
For what?
for preparation, Your Lordship, for the hearing. I'm not prepared for the hearing.
As per the prayer made by the counsel for the petitioner.
Item number 31, 38, and 39 are all.
Come, when the matter will call, counsel for the petitioner. Case is adjourned. Let the matter appear on 17th December.
Well, it's 17th December.
17 December. Obliged.
Which matter?
38 and 39.
31, 38.
And 39.
Lordship, in item 38, I am appearing for the state, Lordship.
Please asking for that.
Lordship,
Okay,
may I-
okay, let the matter call.
My
Yes, call 32. Call the 32.
এর কাগজ দিন না প্লিজ
But it was time to reach them.
নামটা হ্যাঁ একটু এর কাগজ এটা অ্যাপিয়ারেন্স হ্যাঁ হ্যাঁ এই
None appears on behalf of either of the parties. No accommodation is sought for. WPA number 17334 of 2023 is dismissed for default.
Lordship, I appear on behalf of respondent number 1 and 2. Lordship, I apologize for appearing virtually.
A काम करो. None appears on behalf of the petitioner. Counsel for the respondent present. No accommodation is sought for. Yes, next.
Deeply obliged.
Lordship, Mr. Pratik Dhar is appearing in this matter, Your Lordship. I am praying for a week's accommodation.
Who is for the respondent?
Lordship, state.
Have you filed the affidavit reply?
Yes, Your Lordship. Long time back, Your
Where
Lordship.
is the affidavit reply? Only.
Lordship, it has been filed.
Yes. So why you're not coming?
Your Lordship, the matter has just come up this time only.
The matter is listed since 4th of November.
Yes, Your
In
Lordship.
the list. Why you're not ready?
Lordship, I'm being led by him. He's asked me to pray for a week's accommodation.
As per the prayer made by the counsel for the petitioner, the case is adjourned. Let the matter appear on 26th November.
Grateful, Your Lordship.
Next.
I am for the petitioner in this case. I'm online. My lord, the central government has filed its reply, but respondent number 3 and 4 have not filed. So that option may be closed. It's an old matter, my lord.
You are appearing for?
I am appealing for the petitioners, my lord.
Petitioner?
Petitioners. 2 petitioners are there, my lord.
Yes.
They are organizations of a community called.
Who is for the respondent?
Central government is the first respondent, my lord. They have filed their reply. I'll be filing my rejoinder today itself. But I'm prepared for, I'm ready for the hearing, my lord. So if your lordship may fix a date any day.
Where is the rejoinder?
Rejoinder I have sent, my lord. It will be filed just now.
Rejoinder file हुआ?
I have sent, my lord. My clerk will just file it just now.
Where?
Within 5-10 minutes.
Where is your rejoinder, sir?
Rejoinder I have not filed, my lord. My clerk will be filing. He has gone to the.
Where he will file?
Today, my lord, in just 10 minutes, 5 to 10 minutes. Kindly grant me 5 minutes.
Counsel for the petition. None appears on behalf of the respondents. Counsel for the petition submitted. In course of the day, the petitioner will file affidavit in reply. Let the matter appear on 10th December. Yes, next.
Great. My lord, one option 2, 3 and 4 may be closed.
No, I am for the petitioner, my lord. We have filed the opposition, my lord. 2 weeks time is given, my lord, to file the reply, my lord. 2 weeks time is.
My lord, I am filing opposition, but my lord, your lordship kindly gave liberty to correct the cost title. Only your lordship.
What is it?
My lord, in this matter, Life Insurance Corporation is one of the party. But my lord, first party insurance ombudsman. But my lord, I did not skip the insurance ombudsman. Only cost title I had to correct.
What?
Insurance ombudsman and others. Whereas I have stated that Life Insurance Corporation of India and others. That's right.
Counsel for the respondent prays for leave to correct the cost title, correct the name in the cost title of the respondent as insurance of
Insurance ombudsman
and others instead of LIC.
LIC is one of the party.
LIC. Full stop. Leave is granted to the petitioner to correct the name of the respondent in the cost title of the affidavit in opposition. Counsel for the petitioner prays for time to file reply. Let the reply be filed within 2 weeks. List the matter on December.
Grateful to your lordship.
Or in this matter, my lord, 36 and 37 are interconnected. These matters have come up without any notice to us. We are for the petitioner in item number 37. And my lord, 36 and in respect to 36 and 37, the other side has given us a notice that they want to amicably settle the issue also. So in that view, if you lordship kindly adjourn the matter for some time, and if you lordship kindly fix up the matter.
What is the matter? What is the matter?
The matter is, we are in possession of the property in question. Whereas without carrying out any kind of proceedings, without any notice of hearing, nothing, my lord, the state has directed us to vacate the property. Challenging that also with the help of police. Challenging that, we have preferred the repetition. The matter was admitted, interim order was passed by this honorable court, and with a further direction for filing affidavits. Affidavits have been filed. Now matter is pending for final hearing.
What is the settlement?
Or we don't have, we have received this only last week.
Yeah.
The other side has given us an intimation that they want to settle the issue with us. Now, what are the terms of settlement? That has not been disclosed.
You are with the writ petitioner of?
In 37, right? We are the writ petitioner.
What about the 36? 36
and 36, we are the private respondent.
Petitioner in the WPA number 13760 of 2023. And respondent in WPA number 122823 of 2023 are present. None appears on behalf of the petitioner in WPA number 22823 of 2023. Counsel for the petitioner in WPA number 13760 of 2023 submit that he has received a communication from the respondent that the respondent intend to settle the dispute between the petitioner, accordingly prays for time. In view of the submission made by the counsel for the petitioner in WPA 13760 of 2023, the case is adjourned. Let the matter appear on 10th of December.
I'm grateful to
Your Lordship, pray for adjournment on 38 and 39
When it is
to be
fixed,
fixed on 17 December.
Lordship, in this matter, I am appearing for. My lord, may I file my affidavit? There was that.
have you served?
Yes, Lordship.
Yes, copies have been served.
Reply filed?
Yes, Your Lordship.
Reply filed?
No. I have not.
Reply filed by me.
Filed?
Yes,
I have
Yeah.
not received.
you haven't received.
No.
But I have filed.
I'm fine.
I'll check it out once again.
My lord, my affidavit.
I have to see. I have filed reply in all matters.
Respondents have filed affidavit in opposition. After serving the copy to the land council for the petition, let the same
Phone
be
number
kept with the council for the petition, place for time to file affidavit in opposition, affidavit in reply. Let affidavit in reply be filed within 2 weeks. Is the matter when was it is fixed earlier?
Yes, Your Lordship.
Let the matter appear on
কি বলেন?
17 bola. Abe next date
10th
bola.
December.
17 December.
17 December.
Lordship on 17.
17 December. Obliged, Your Lordship. আমি দিয়ে দিয়েছি। Number 25. Correction. I have filed my
Okay.
Lordship kindly recorded.
35 में ना correction बोला था ना and file affidavit. The respondent file affidavit in opposition. Let the same be kept with. Yes, next.
Time for the petitioner, my lord. Jila Purishad. Jila Purishad.
You're for the petitioner.
I'm for the petitioner. My lord, what happened, my lord? This is
Answering respondent, he's not the Jila Parishad is answering this one.
my lord, but
Not appearing, not appearing.
I'm placing the fact, my lord, there is no, I think it will be a disputed question because my tenure has expired on 28th September 2025. But till the new incumbent is awarded with the work through a tender process, I have been directed to continue it. That is, I am continuing till date. And only that there is no written order to continue the collection of toll collection during this interim period till that. Then next tender has been, date of the tender is fixed on 27th November 2025. That is the submission, my lord. Otherwise, my tender tenure has completed.
So what do you want now?
I'm not asking for anything except an order to give me a written instruction to continue till the new incumbent is. As per their verbal direction, I'm collecting the toll tax and depositing the same.
Correct.
That is the thing. Nothing else.
So you are getting the payment also. You are getting the payment of also.
I'm collecting the toll tax and depositing it.
So you're not getting your remuneration.
No question of remuneration. It is on tender basis lease. Under lease, I've been awarded with a lease for 1 year.
That 1 year is over.
Over.
Thereafter, you are continuing with the tender work.
As per their direction.
Correct.
Till
Now,
new.
Subsequently, they have issued the new tender.
Tender.
The period which you have worked, they
Yes.
have not issued any work order to you.
No.
But whether the payment has been made.
They will not make payment because whatever I collect, what is the lease amount to be deposited, I am depositing the same.
So what benefit you will get?
I'm only direction that I am continuing with collection of toll tax on and from 29th September till today.
Correct. Till today.
Till today. On 27th November, date of next tender has been fixed.
November 2025.
25. That is my instruction. I'm told. Only a written direction to continue.
When your tender was expired?
Expired 28th September 2025.
202. So 2025.
2025. This year, in this year.
This year. So
nothing more. Because what is the matter was that during my tenure in the year 2023, they invited a tender. That was objected by me. And I filed this writ application not to proceed with any tender during my duration.
why?
Because I was
Where is their extension order?
No. Yes. I was working. Your Lordship kindly comes at page 38 P3. page 38 of my petition. Your Lordship kindly comes to 2 years. Second paragraph. It is for 2 years.
Correct.
So my 2 years has already been.
Your 2 years has been completed on
No,
28 September
my
2025.
lord.
Whether the new tender was issued?
No,
No,
not yet.
no.
And you are continuing.
I'm continuing as per their verbal direction.
Whether there is any extension order, written extension
No, no,
order?
no. That is what I am submitting before your Lordship.
What?
That is the only to direct.
Kindly come to a prayer A of the writ petition.
This application by this time has become infructuous, has no merit at all, because I challenged that tender which was published by them in their 2033 when my tender was alive. They were state from.
Nothing remains in this writ petition.
Nothing remains. I have nothing remains in
I
this
am
application.
dismissing it as infructuous.
Your Lordship can dispose it of. No question on dismissing.
What disposal? What order you will
I
get?
will not. There is only a direction that I am continuing to record it. That I, as per direction, I am continuing. Otherwise.
You take the direction from the authority under which you are working. But there is, sir, your prayer is something else. That is over.
That portion is still retrospect. There is nothing. They were staying from proceeding with any tender process during my tenure of 2 years. So we have just that will exhaust the 28 of this. So if you record my computer, then I will ask for that other deadline.
The petitioner has filed the present date application challenging the tender notice for e-auction dated 22nd September 2023. But the learned counsel for the petition submitted in this page number 38 is in your favor. So why you file this writ application? But in the meantime, the respondents have already issued the work order in favor of the petitioner till 28th of September 2025, and the said work period is also completed. This court find that the grievance which the petitioner has raised in the present writ application has become infectious. Accordingly, WPA number so is disposed of. Accordingly, connected applications also disposed of.
I think recording my
Yes.
No. I am continuing with that part.
That I am not recorded. You are.
Can record myself as my company.
Yes. Call the supplementary list. Supplementary list. कौन अदर कोड में रन कर रहा है? कौन? फोर्टी में रन कर रहा है क्या चीज? रिट पिटीशन वो तो रिलीज हो गया. कौन लिखे दे? कोर्ट ऑफिसर कुछ नहीं कर सकता. Record has not come.
Recording mentioned and
Yes, okay, record तो आ गया. Okay.
Who to record?
got the file.
फिर
PCI में बनाना है, होमबल बनाना है. तुम्ही काय है?
फिर लिस्ट क्यों नहीं हुआ? कौन बोला बेल लेके आओ? कौन बोला लिस्ट नहीं करेगा? लेके बुलाओ यहाँ पे. Call here. Who is the person? Just please wait. Let him listen. Till tomorrow. So let come tomorrow. Okay. Come tomorrow. Tomorrow इसको tomorrow as a urgent listed motion talk में कर. So no, tomorrow for extension of interim order under the heading extension of interim order. Interim order. Yes, call the list. Where is the affidavit in opposition? To whom? No affidavit in opposition. And yes, have you received? Have you filed the reply? Where you in the department? Affidavit नहीं है. Where is the dashboard number 2 has not disbursed the amount? Where from you got it? Page 52. You are the cyber swift. Yes. So this is the total 15 items. 15 items. 15 items. Page 4. So that's why where is the admission? How you can say admitted? Where is that admission? Sure. Where is your cancellation notice, recalling of the tender? No, this is with regard to the citizen relationship to be cancelled. Yes, then. Where is their affidavit in opposition? Give the copy. Where is the admission in the affidavit? What they have stated in the affidavit? No, it is your letter. Where is the admission in the affidavit? Show me. What is the reply to the paragraph 7? What is the reply in the affidavit now with regard to the paragraph 7 of your writ application? Yes, give that. Come. Come. The petitioner has filed the present writ application praying for release of an outstanding dues of rupees 34,46,600. 34,45,600. 6 full stop. The where is your tender notice? The rest. Who has issued this tender notice? Respondent number 2 or 1? The respondent number 1 has issued a work order to the petitioner on 24th of May 2019 for supply of altogether 15 items. Full stop. On receipt of the work order, comma, the petitioner has supplied the following materials, namely this one, paragraph 7, page 4, paragraph 7 A to G. Following items. After supply of the above mentioned materials, comma, the petitioner has raised invoices to the respondent number 1. The respondent number 1 has forwarded the said invoices to the respondent number 2 for release of the said amount, so as to enable the respondent number 1 to pay the amount of rupees 34,45,600 in favor of the petitioner as per the invoice raised by the petitioner. In spite of the invoice raised by the petitioner, comma, the respondent number 1 has not released the amount. Accordingly, the petitioner had sent a notice to the respondent number 1, calling upon the respondent number 1 for payment of the said amount. On receipt of the notice of the petitioner, comma, the respondent number 1 has sent a reply stating as follows, page 64, second paragraph. As the respondent number 2 has not released the amount, the respondent number 2, instead of releasing the amount, has issued an order dated 3rd March 2020 by recalling the work order issued in favor of the petitioner. As the amount has not been released, comma, the petitioner has filed the present writ application. Has not been released, comma, the petitioner has filed the present writ application. Full stop. The respondents have filed the affidavit in opposition. Respondent number 1. Who has filed the number 1 or number 2? Affidavit? number 1 has filed the affidavit in opposition, wherein the respondent number 1 has admitted that the petitioner has supplied part of the materials as mentioned above and has raised the invoices, and the respondent number 1 has forwarded the same to the respondent number 2, but the respondent number 2 has not released the said amount, due to which the respondent number 1 is not in a position to pay the amount to the petitioner. Consider the submission made by the counsel for the petitioner, peruse the materials on record. It is admitted that the respondent number 1 has issued the work order for supply of 15 items. Out of the 15 items, some of the items have been supplied as mentioned above. And after supply of the materials, the petitioner has raised invoices. On receipt of the invoices, the respondent number 1 has forwarded the same to the respondent number 2 for release of the said amount, but the respondent number 2 has not released the said amount. This could find that the respondent number 1 has admitted that the petitioner has supplied the materials for a sum of rupees 34,45,600, but the respondent number 1 has not released the said amount only on the ground that the respondent number 2 has not paid the said amount. Considering the above, this court find that no purpose would be served by keeping him, and this could find that the respondent has admitted that the petitioner has supplied the amount and raised the invoices only because the respondent number 2 has not clear the amount, due to which the respondent number 1 is not in a position to pay the amount. Accordingly, the respondent number 2, that is the, who is the respondent number 2? Respondent Labor Department. Who is the authority? Where is the cancellation order? The Special Secretary from a Labor Department is directed to immediately release the amount of rupees 34 lakh 45,600 to in favor of the petition number, in favor of the respondent number 1, and the respondent number 1 is directed to release the said amount immediately, and the respondent number the respondent number 2 is directed to release immediately to release the amount of rupees 34,45,600 within a period of 3 weeks from the date of receipt of the copy of this order in favor of the respondent number 1. And if the respondent number 1 is received the said amount from the respondent number 2, the respondent number 1 immediately within a week from the date of receipt of the order shall release the said amount in favor of the petitioner. WPA number 27. Let's go. Yes, nobody. You are appearing for? Why not today? Huh? As per the prayer made by the counsel for the respondent number 1, case is adjourned. Let the matter appear on 17th December. Yes. Affidavit exchange. Readings completed. Filed.
So therefore, I didn't want against them. Now, to Mr. Modi of Calcutta is out of that 675. That can be 675.
Item number 43, 43 and 63. It is submitted. It is submitted by the General Council for the parties that item number 43, that is WPA 26747 of 2023, and item number 63 and WPA number 17864 of 2024 are connected matter, and in both the matters the report by way of affidavit and exception by way of affidavit exception has been filed and matter is ready for hearing. In view of the submission made by the counsel for the petitioner, let the matter appear on when 3rd September, 3rd December. Gun license. He died, yes. What is the ground for rejection? Okay. Who is for the authority? Have they filed the affidavit? File the affidavit. What is the can? Expeditious. Where is the respondent? Huh? Have they filed affidavit in opposition? So what can be done? Come tomorrow? But other side is not there. They are not. So what you want now? What direction? Counsel for the petition is present. None appears on behalf of the respondent. Police. The petition is directed to inform the next date of hearing to the respondent and file the affidavit of service. This is the matter on 3rd December 2025. Inform and come on common 3rd. Yes. क्या उस लोग क्या बोलता है क्या ऑर्डर अपलोड नहीं हुआ हाँ मेंशन किया हाँ फिर बाद में बोला था कर दो करके हाँ 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 क्या हुआ यस ठीक है उसको मेंशन करने तो हम कर दें
Item 47 is a very short item 47.
Appellate side.
Appellate side, your lordship. I know the original side matter is fixed, your lordship. Only thing, if a date can be fixed, it's a very short matter, a complex situation of 3 provisions of the Companies Act. There's an interplay, and the interim order is there. If it can be extended and a date be fixed in any time convenient to your lordship.
Item 47.
Item 47. Your lordship, the Union of India is appearing for the other side. I'll inform Mr. Torun Jyoti Tiwari is there.
So what you want?
And extension of interim order and a short date be.
Interim order is still today.
No, it's still 20th, your lordship. But I also
November.
I'm also praying for a date be fixed.
Date already 20th. Come on 20th November. I am fixing on 20th November.
No, 20.
Yes.
Or it can be fixed on 19th if your lordship.
My officer has gone. Not. Yes. What? Yes. Challenging the willful defaulter. Willful defaulter of what? Not under the SURFACE. It is listed. Mention tomorrow. Tuesday is the mentioning day. Mention tomorrow. Yes, call the list. Now, I will record. Though I dictated the order, subsequently the respondents came, he wanted to, so I have not passed any order. I will pass an order. Record. Where is the order? Give the order copy. You know, that's why since morning, in your presence, Mr. Singh has mentioned the matter because he wanted to cite one judgment. That's why you not signed the order. Subsequently, my determination has been changed. Whether can I sign the order? And you have started mentioning before the court that order has not been uploaded. Go and complain before the Chief Justice. Where is the order? Show me. I am passing the order. Here in now. Where is the order? Mentioning without any order. Yes, call the list.
You are opposing this application.
Both the applications dismissed.
Obliged, your lordships. Obliged.
Dismissed. So this court has not allowed for substitution. Only this court is directed to delete the name of the plaintiff number 1.
Deeply obliged, Your Lordship.
Why to be mentioned? Yes, who is appearing? Delivered. Nobody is appearing. Record and order. The matter was listed on 27th of October 2025 on receipt of the report from the office of the London Master. Full stop. As none appears on behalf of either of the parties, accordingly, this court directed to issue notice upon both the parties. The earlier advocate died. Which matter? You are appearing for whom? Who has applied for the decree? Plaintiff. You are for the opposite party or dependent? Okay, no problem. क्या बोला? Both the parties. The registrar original side has filed the report intimating that the notice has been served upon the parties. But in spite of the receipt of the notice, none appears on behalf of any of the parties. Mr. What is your name? Since appearing on behalf of the defendant and submit that they have been instructed to appear in the matter on behalf of the defendant. It is found that this court has passed an order on 6th of August 2024, and as per the requisite submitted by the learned counsel for the defendant, the certified copy of the decree was provided to the parties. Subsequently, the plaintiff has engaged another advocate and without going through the record has taken leave from this court to draw and complete the decree, and accordingly this court has granted leave, and again the department has prepared the decree. Subsequently, the department came to know the decree was already passed and signed by this court. Good. And second time a decree was passed and decree was signed. In view of the above, this court finds that once the decree has already been passed by this court on 6th of August 2024, thus the second decree prepared by the department as per the leave granted by the court is null and void. Accordingly, the second decree prepared by the department be treated as cancelled. Got it? Next. Report है 7 November. None appears on behalf of either of the parties. Let the matter appear on 18th November. Yes. Same heading, under the same heading. Ready? 3 p.m. matter. Yes, anything, what? Yes. Yes.
Do you know anybody by the name of R.K. Khanna? Rajesh Kumar Khanna, na? Right. No, R.K. Khanna, in the name of Mr. R.K. Khanna, solicitor, advocate.
Yes. The advocate of RK Agencies Limited from 1984 until 1991.
Now, can you recollect as to whether Mr. R.K. Khanna of Khanna and Company had represented your father or any of your group companies prior to this matter?
I do not recollect, sir.
So, do I take it that it is possible that Mr. Khanna had represented, but you don't have knowledge of it?
My family has known Mr. Khanna for many years. Prior to this. So, since I was a child, in fact. So I do not think that he represented any of our other companies, but I cannot know for sure.
Companies? Any of our companies?
Any of our other companies, but I cannot know for sure.
Now, when you say that my family knew Mr. R.K. Khanna, could you be a little more specific as to who knew, or was he a family friend known to all of you in the family?
I cannot answer.
You cannot answer that.
I cannot answer.
So I can take it that Mr. Khanna also knew your father?
He would have done certainly.
Okay. Now, এটা exhibit কত? Exhibit. আর এটা? এটা হচ্ছে A/4. Now, kindly take exhibit B/4, A/4 in this proceedings.
Yeah.
Can you identify this document?
Sorry?
Can you identify this document?
This is the standard printed letter of liaison.
Standard printed letter of liaison
Of the Central Bank of India, which has been signed by Khanna.
Now,
I'm sorry, I would add, on account of Messrs. RK Agencies Limited for outstanding general balance.
why is it addressed to Mr. R.K. Khanna of Khanna and Company?
Yes.
Why is this letter addressed to by Mr. R.K. Khanna?
By Mr. RK.
Yes.
Because he was representing RK Agencies.
Okay. So, will I be correct in saying that on 1st of December 1984, Mr. R.K. Khanna of Khanna and Company had authorized the bank to create a lien in respect of receipt number 11/190 for a sum of rupees 20 lakhs on account of RK Agencies.
Yes, that's correct.
That's correct. Do you have any idea as to what the word lien means?
I think so.
Could you explain? Would I be right in saying, could you explain again? Would I be right in saying that the lien means that Central Bank of India can hold this amount in respect of its outstanding dues?
In respect of its outstanding dues.
First yes or no, then thereafter.
Sorry?
First say yes or no, because I've given you a suggestion.
Your answer is incomplete. The bank.
My question is incomplete.
Your question, your definition is.
Okay.
The bank itself gave one definition of lien at ground B of its special leave petition before the Supreme Court.
My question to you,
So
I'm sorry.
The bank may retain the money of RK Agencies Limited or a debt of RK Agencies. That is the definition of
দেখুন তারা কি বললো the bank no liquidation. কোথায় গেলি আর কে এজেন্সিদের বাইরে কোনো ব্যবসা ছিল কি ফরেনার অ্যাকাউন্ট ছিল ওকে
Yeah.
yes
Since RK Agencies Limited owed no money to the bank, it was already adjudicated that the letter of lien meant Exhibit A4 meant nothing at all.
now এই চিঠিটা when you say that it was adjudicated more specific as to whom, by whom and where and when. By whom, where and whom and when.
I think that the details may be given at the time of argument, but certainly Justice Maharaj Sinha, the single judge, adjudicated that the lien meant nothing.
Was any appeal carried from that order?
Yes.
Can you tell my lord what was the outcome of the appeal?
Division bench upheld the decree of Justice Maharaj Sinha. And when that was appealed in the Supreme Court saw no reason to interfere with the decision of the division bench. There is one small proviso in the decision of the division. Which was based on certain prejudice created by Mr. Mitra, the senior counsel of the bench.
Let him not take names, fellow.
On the last day of appeal. And the division bench, without giving
That orders are not exhibited. Then what is the necessity?
But he is interpreting the order in his own way.
You can't interpret. Let the court interpret that.
based on certain statements
What?
made by Mr. Mitra. On the last
Sorry, so not to make all the statement, whatever the judgment, the court will consider at the time of passing there.
he asked the question.
What is the question?
The question was he referred to a particular order saying that so far as this lien is concerned, that was yes. So he said that this order, the court has already said that this lien is not relevant. So I said, which order are you referring to? So he referred to one order. Then I asked him that was any appeal carried from that order. He said, yes, the appeal was carried and the decree was upheld. And it was upheld up to the Supreme Court. Now he says that provided that there is something more in the order, which he is now trying to explain.
There was a caveat in the decree that the bank is given an opportunity to try and persuade an appropriate court.
That is the liberty given.
That is a liberty given by the court.
That's all. Yes, next.
I suggest to you that your interpretation of the order of the Court of Appeal is wholly incorrect.
I disagree.
I further suggest to you that the Court of Appeal had expressly come to a conclusion that a finding, not the conclusion, a finding that this lien was provided by RK agencies for securing the claim, outstanding claim of SL Setia Liners and Ramplace.
If we examine all the documents submitted by the bank to the court, the bank stated repeatedly that it held a decree against SL Setia Liners. Now the bank has admitted that this was not true. The court was deceived by the bank's repeated assertion that it actually had repeated assertion that it held a decree for its claim. The bank was not owed any money by SL Setia Liners Limited. That has been established only in this trial. By SL Setia Liners Limited.
Yes.
When you depose before my lord that the bank has admitted that this lien has no connection with the outstanding dues of SL Setia Liners and Ramplace, exactly which document are you referring to? Which document or pleading are you referring to?
Sorry, could you repeat?
Question to repeat. Outstanding dues of SL Setia Liners and Ramplace Limited. Which document or pleading are you referring? Which
document you are referring?
Or pleading are you referring to? Start hoche when you say that the bank has made an admission.
First, you were the question. When you
Mike is the witness to the
document
Which document or pleading are you referring to?
I did not say that the bank has admitted it has no claim against.
I did not admitted that bank.
I did not say that the bank had no claim against the foreign companies. I only said that the bank has admitted that it has no claim against RK agency. That is in the records.
Yes, next.
Kindly come to exhibit. To exhibit A by 3. 3. You will find that Mr. Khanna and company is writing to Central Manager, Central Bank of India, and the letter starts with in invited commas under instructions from and behalf of our clients RK agencies. Were you the person who gave these instructions?
No, I believe Mr. S.K. Bhattacharya.
So you won't be in a position to contradict whatever instructions Mr. Bhattacharya had given to Mr. R.K. Khanna, which is recorded in this order, in this letter.
I have no objection to the letter. It is a matter of record. It has been for a long time.
I am not in. It's not a question of objection. It's a question is do you accept the contents of the letter as true and correct?
Yes.
Now, this letter, by this letter, Mr. R.K. Khanna had created a fixed deposit. Do you remember? Do you find that?
Yes.
And that fixed deposit was for a sum of rupees 20 lakhs, which was created by check number J148553 dated 27 November 84. Will I be also correct in saying that the fixed deposit was kept under instructions of Mr. Bhattacharya as to be held by the bank in lien for the dues of foreigners' account?
Not at all.
Does RK agencies have a foreigner account with Central Bank of India?
No.
So is it possible that Mr. RK Khanna was instructed by Mr. Bhattacharya to create a lien in respect of a foreigner's account held by Central Bank of India?
No, because this has already been explained at length in the earlier trial. There was a proposal for a loan.
For a loan.
See, there was a proposal for a loan to the foreign, subject to permission of the Reserve Bank of India. And that permission would be obtained through the Central Bank of India as authorized dealer for foreign exchange. And in order to process the application with the Reserve Bank of India, the money had to be deposited with the Central Bank of India. At the time, Mr. Bhattacharjee was not aware of whatever might be the purpose for the loan. And since the loan never took place, it became immaterial later.
If I suggest to you that this lien was created at a point of time to secure the dues of the companies Ram Place and SL Setia Liners, who were facing insolvency proceedings in England. Would you agree with me?
It's completely because the bank filed a suit against SL Setia Liners Limited, and it's part of the record, on 30th of January 1985. So that's one part of it. That's one part of your answer. When the bank itself wrote to the Reserve Bank of India on 29th of November 1985, Exhibit 813, seeking permission to remit the money to London. The bank specified that it wanted to adjust the debt, the alleged debt, I should say, of SL Setia Liners Limited only. So this money was not deposited for any proceedings in London at the time.
If I suggest to you that your deposition as to the contents of this letter, being Exhibit A3, is contrary to the records in the present case, would you agree with 330, I believe? Okay.
The defendant's witness is present. Cross-examination resumed, but due to paucity of time, cross-examination could not be completed. Let the matter appear tomorrow at 3 p.m. for further cross-examination. 3 p.m.
This matter is fixed for tomorrow also, but my advocate on record, my lord, is ill. He's undergone a surgery, my lord, and I would request, my lord, if some more time can be given. I did, but my advocate recorded operation.
When he will be available?
Because
he rang me up yesterday saying that on Friday they mentioned, but he could not convey because he's not in a position to speak. He had some operation and he's completely bedridden. And he said he will be joining 2 weeks later.
Because he has come from Pune.
But there is so many questions. Asking them.
দেবো অপোজ করুন আমি কোনো ইনস্ট্রাকশন পাচ্ছি
2 weeks after. 2 weeks after.
Yeah, that is entirely of course.
Indeed, determination 2 p.m. it is very difficult.
তোরা কবে হোল্ডে করেছি 1 ঘন্টা করে করে তো সারাক্ষণ করে যাবে জ্ঞান দিচ্ছিস কেন আমার এই মামলাটাই
26, 27, 28, 3 p.m. 26, 27. Let the matter appear on 26, 27 and 28 November at 3 p.m. For the cross examination. Yes.
Upon notice, Mr. Sinha is there.
Yes.
Page.
25th, 26, 27.
Reading
25, 26, 27. 25, 26. Yes.
My lord, I'm mentioning the matter for notice to Mr. Sinha. Why matter to Kill Street? The matter is ready for hearing. Because of this non-hearing, my testamentary suit has got stopped. My lord has, Mr. Justice Arvind Mukherjee has asked me to first clear this matter.
Which matter?
It is not so not
Writ for final hearing, my lord,
for petition. Actions, everything has been.
serious issues, not a frauds were if involved, if I remember correctly, my lord. Can I ask him?
It will come in the hearing of the hearing matter.
Lord, could it appear as to be mentioned after some, in case your lordship is inclined to add, not Mr. Amitesh Banerjee was appearing at one stage, not he's no longer there, not I need to find out who can appear. But if it could appear as to be mentioned, but after a week, not I'll at least not get someone to appear and then your lordship can fix a date.
Let it appear on 12th as to be mentioned.
I'm grateful to your lordship. So that in the meantime,
12th go to be mentioned directly.
I'm grateful to your lordship, not for adopting our request, not for 3 p.m., not for the original site. I'm very grateful.
All parties is to be adjusted.
Yes, I'm very grateful.
My lord wanted me to come back. Yes, you were mentioning something. Your junior is mentioning something. What has happened, you know.
Yes,
I have dictated the order. Subsequent, Mr. Singh has come with the citation.
I was also there, my lord.
You were also there. So I told that I will not sign the order. Let the hearing is to be concluded. But by that time, the
even I was surprised, my lord. If the Mr. Singh had the same submission, but he had made a complete different submission before Justice Rai's court.
Okay, I will record that order. Where is where is that order? Give that order, I will pass it out.
Justice Onudhura's order. And my lord had pleased to pass the order in the open court.
Correct. But I not signed.
Yes. And my lord, what is the department showing that the order is passed? And the next date, as directed by the same order of my lord,
what?
On 19th November.
Which department said order is passed? Which department say order passed?
Yes, my lord. See, same date. That's why I have shown my lord's officer also. It is in the public website, my lord. That is the thing. And particularly when. And even the returnable date was given by that order by my lord.
That perhaps. Okay, let us see.
With your kind leave,
See
your
that
lordship,
My lord will kindly
mention WPO 801 for inclusion, your lordships.
Why?
There's a grave urgency, your lordships, since there's an order that has been passed by the Fraud Identification Committee of SBI, your lordships. There is a possibility and a chance for RBI to take actions against us, your lordships. I'll be obliged if your lordships may kindly keep
Action
it on
against
this.
you, your client,
Yes, your
the
lordship.
petitioner.
The petitioners, your lordship.
Right, so we have started.
Much
missing
obliged.
code 38. We have started missing code 38.
Come here.
Yeah. Yes, obviously.
If you are missing there, come here.
Yes, I had matter even item number 45 today. That will I will become. But only two things I want to indicate that by virtue of that order given by my lord, the last line was as we show in virtual. The next appearing date is 1911. That is written there in the.
Okay, let me see.
Kindly
Well,
see
only
that.
one
Let me
prayer.
see.
If the record will call the record, then
My lord, one prayer. My lord will not take
And
me amiss.
Justice Rai's order,
Justice Rai's order clearly note that what was the submission of the judgment debtor. They had made a complete Mr. So-and-so learned counsel appearing for the judgment debtor submits that there was no urgency in the eye of law for obtaining the leave and to move the application without the decree being drawn up. We had taken the leave of my lord, even my lord knows.
Yes.
I'm just saying my lord will not take me amiss. I had to bring in my senior. I tender my apology.
Okay.
I'm grateful, my lord.